Next
Interim,
Tuesday,
interim may be continued. There is interim.
item 9,
Yes, your lord.
the motion matter.
My lord, fixed for a report, my lord. And there is some interim,
That's a report. Nice. The interim order shall continue till the next day.
my lord.
List on next Tuesday.
Must have
Date of- Next Tuesday.
May I please, your lordship? Lordship, I beg to mention item number 34, lordship.
34
34, lordship.
bail hearing.
Yes,
AB.
lordship.
Yeah.
Item, yes, there is receipt. Item may be adjourned for the day, lordship. Any date on next week, lordship?
Because case diary has been received. Interim is there.
No, no.
Interim is not there.
Not that.
But, even
Next
if it's
week,
not there, how about next Monday? Next Monday? The case diary is received and shall be retained. The prayer of the learned council, the matter is adjourned for the day and fixed on.
My lord.
Suggest
Yes.
next Monday or Tuesday will be good. for
Yes,
you.
on Tuesday or next.
Next Tuesday?
Yes,
What is the date? Next Tuesday?
On 3rd of February, my lord.
3rd of February.
lordship. Deeply obliged.
May it please your lordship, I beg to mention for listing of an anticipatory bill filed on 19th of January, your lordship, up to 7 years. Any date tomorrow or day after
Yes.
tomorrow. Deeply obliged.
May I please, your lordship? Yes, I mentioned for item number 39. Most probably CD is not received. 39 is very not received. Interim is there, lordship, that may be controlled.
Case diary is not received, issue reminder. Interim shall continue till next date, list after. You can give a date next week, date middle of
Date
next.
may be fixed on my lord, 12 of February, 12 to 12th of February. Interim may be controlled, lordship. Deeply obliged.
May it please your lordship. Lordship, I'm praying for listing of an AB, my lord, for tomorrow. my lord. Deeply. obliged.
Lordship, I beg to mention bail, your lordship. Listing of bail.
Listing.
May I please, your lordship? Lordship, I beg to mention item number 40, lordship. A report was called for, probably it's not been received.
40, my lord. Yes, report not yet received.
Report, no, not CD, no? Report was called.
Report,
All
lordship.
report.
Report as called for, not yet received, issue reminder. Interim
Interim was there, lordship.
interim order shall continue till the next date of listing. List the matter on
On my lord, 12 to
12th to
Lordship, same pair for item number 10 also, lordship.
for 10.
Whether any case has been registered against the petitioner or not, that report was called for. Item number 10, M10.
10 to motion method.
কিন্তু আগতে order আছে।
That's why motion matter. There was a order.
Yes,
Earlier it came.
Yes, yes.
Same date.
On 12 to 12.
lordship. Interim was there, lordship. Obliged.
Extended. Interim.
Lordship. obliged.
May I please your lordship? My lord, I'm praying for listing of a criminal petition, my lord. It is a pending matter, my lord. It was last listed on 6/6/2022, my lord. Tomorrow or day after.
This week, sometime this week.
Your lordship, I beg to mention an item for listing, anticipatory bill. Tomorrow, your lordship.
Tomorrow, day after.
Obliged.
May I please your lordship, I beg to mention item number 29. 29. Lordship, here charges submitted lordship. On 7/1/26, lordship.
Right.
NDPS case number is 8/2026.
Should we call for the scan copy?
Lordship.
Scan copy.
Lordship.
They submitted MDECA Learned Council, Standing Council for the NCB/prosecution submits that. In the meantime, charge sheet has been submitted, leading to registration of NDPS case number
8/26. 2026.
8/2026. In view of the same, call for the scan copy of the case diary and the charge sheet.
Lordship, TCR lordship. It is
TCR.
pending before additional district and session judge now 1 lordship.
Call for the TCR within bracket comprising case diary and charge sheet on the court of additional session judge number 1, Metro. Kindly inform the other side.
Lordship. Highly
Just a minute, date. I'm not given the date.
Yeah, please, lordship.
When do you suggest
Lordship, a date may be fixed, Lordship.
this matter?
Yes, this matter, Lordship.
No, you can suggest a date, or we fix it
Lordship on
next Wednesday. Huh?
6th of February.
Yeah, 6th. Oh, no problem.
Much
6th
obliged.
to
Highly obliged.
Fabulous Lordship, prayer for listing regular bail Lordship, tomorrow Lordship, Obliged Lordship.
May it please your lordship, my lord, in item number 13, my lord. Every month it may come up Friday, on Friday or Thursday, my lord, because we have filed an additional affidavit today, my lord. 13.
Diary has come.
No,
You retain the
it's a
diary.
motion matter, possibly, my lord.
It's a motion matter. I
Motion
see.
matter, oh,
The prayer of the learned council. Submitting that an additional affidavit has been filed. The matter may be listed on Thursday, that is
Friday, man.
Friday. List on, what will be the date on Friday?
Friday,
30.
30.
30.
Oblige your lordship.
May I please your lordship, my lord, I have filed an additional affidavit in connection with item number 22, my lord.
Okay.
That may be called for, my lord. Obliged.
May I please your lordship? Lordship, I beg to mention item number 16. 16.
16.
Yes, lordship, 16. Kindly pass over for 2 days, lordship. Fix to next week, lordship.
Next week,
Next week, yes.
the prayer of the learned council adjourned for the date fixed. You want me to fix
Yes, lordship.
a date?
Yes.
6/2.
Yes, obliged.
May it please Lordship, I filed one bail application, my lord, on 22, my lord, can it be tomorrow, my lord?
Tomorrow or day after. AB or BA?
BA, my lord.
So BA.
BA, my lord.
Tomorrow you want or day after?
Tomorrow, day after. Fine.
From the item number.
May I please your lordship, lordship, and item number 120, senior counsel on lakes. Can you pass over the matter for something?
In this case, I think we'll need the updated case diary.
Yes, yes,
Is it?
yes.
We'll wait, no, updated case diary. It's a date.
Item number 2.
No, 1, 2, and 3.
120. 4, item number
I'm big.
4.
So take it up. One. Item 4.
Oh, sorry, the mention was there.
Yeah, please.
Yeah, please your lordship, can you be after some time, my senior ones like that?
This all.
Obliged, my lordship.
Item 5.
May it please your lordship. My lord, here mandatory period is over. And we have, my lord, filed the application on 19th. But your lordship was not sitting here. For that, my lord, it could not be listed. So, my lord, if charge sheet is not laid on the 19th,
Mhm.
on the 22nd, my lord, when we have completed the 90 days,
Yeah.
we will be entitled to bail. Even after 22nd charge sheet is laid, we will be entitled to bail on the very day when 90 days is over. And the bail petition is pending. That is the law, my lord.
Yes.
Your lordship knows, my lord.
Yeah, no issue.
So,
It
your
was
lordship,
a-
can you
it
take
is a
after some
subsequent
time?
bill application.
Yes, subsequent, my lord.
why,
It's a 483 bail application.
Statutory bail, I think anybody can take it up.
Yes, that is, my lord. We have filed before the registry also, learned registry, but it was not listed, my lord. We have mentioned twice.
Because otherwise, as you know, 302 also, magistrate also gives
Yes,
statutory bail, right? Otherwise, they cannot give.
my
but
lord. Only
303
thing is, my lord, whether charge sheet is laid on till 22nd.
Yeah.
That is the main thing, my lord.
I will get the instruction, my lord.
Can
If
you
charge
get
sheet
the-
file, when my lord charge sheet
Yes,
file,
yes, kindly get the inspection.
along with the book.
So if they are entitled, they must go on bail.
And one more thing, my lord. Charge sheet, copy and what type of charge sheet? My lord, because why we apprehend, my lord, nowadays part charge is filed, my lord, without conclusive materials, my lord. So that has to be also taken care of, my lord. Right of the accused are there, my lord. Deeply obvious.
You'll take instruction.
Yes. What's it?
May it please your lordship. This is a regular bail application, lordship. Informant Durga Bora loss against the Zintu Gogoi, lordship. FIR page number, lordship, 21, lordship. Original FIR page number, lordship. May I read, lordship?
21.
21, original FIR page number, Lordship. May I read, Lordship?
Mhm.
সন্মানপূৰ্বক বিধি নিবেদন এয়ে যে 1/1/2026 তাৰিখে সন্ধিয়া প্ৰায় 7:30 মান বজাত মোৰ কন্যা দুগৰাকীয়ে 14 আৰু 15 বছৰীয়া ওচৰৰ সমনীয়াৰ সৈতে মোৰ ঘৰৰ সমীপত মোৰ ভাইটি শ্ৰী দেৱজিৎ গগৈৰ ঘৰত সন্মুখত নতুন বছৰৰ ভোজ খাবলৈ যা যোগ কৰি থকা অৱস্থাত অপপক্ষই মোৰ সেই স্থানত প্ৰৱেশ কৰি বিভিন্ন অশ্লীল ভাষাত কোৱাৰ লগতে ছোৱালী কেইজনীলৈ দেখুওৱা অশ্লীল ইংগিত দিয়ে। উক্ত সময়ত অধীনত মোৰ ভাইটি মোৰ ঘৰৰ জুইশালত বহি থাকো আৰু সেই কথা গম পাই অপপক্ষই হাতত এখন চোকা দা লৈ দুৱাৰ খুলি কোনো কাৰণ নোহোৱাকৈ ভাইটি ঘৰত প্ৰৱেশ কৰি প্ৰথমে মোৰ খুৰীক নিভা গগৈৰ দাৰেৰে আক্ৰমণ কৰি মোৰ পিঠিত গদিয়াই আৰু গুৰুত্ব জখম কৰে। মই মোৰ খুৰীক বচাবলৈ চেষ্টা কৰা অপপক্ষই মোক চোকা দাৰেৰে টান মৰা উদ্দেশ্যে মোৰ মূৰত উপৰ্যুপৰি ঘুপিয়াই কাটি গুৰুত্ব জখম কৰাৰ লগতে শাৰীৰিক বিভিন্ন স্থানত দাৰে গালি মাৰি গুৰুত্ব জখম কৰি অন্ধাৰ সুযোগ লৈ পলাই যায়। গতিকে দয়ালু মহোদয় দয়া কৰি উচিত ব্যৱস্থা প্ৰয়োজন। Upon receipt of the said Azahar Lordship, Gugamuk Police registered a case under section registered a case as a Gugamuk case number 1/2026 under section 290 329 clause 3 296 117 clause 2 118 clause 1 109 clause 1 Lordship. This is a session section Lordship. Petitioner arrested on 9/1/2026 Lordship. On the same day, he was produced before the Learned Judicial Magistrate Dhemaji Lordship. On the same day, at the time of production Lordship, we file a bail application, but Honorable Learned JMFC reject the bail application Lordship. With the reason to session table section is there Lordship. Actual fact of this case Lordship, petitioner wife Lordship lodged a FIR in the year of 2022 Lordship at Gugamuk Police Station. Gugamuk Police searched Chamit Lordship, and trial has been going at Dhemaji District and Session Judge Dhemaji Lordship. Case is fixed for argument Lordship 31/2026 Lordship. Lordship, number of occasion informant Lordship threatening the petitioner as well as his wife to withdraw the case Lordship. They are not withdraw. That's why present case is filed against the accused Lordship. And in the on the day of incident Lordship 1/1/2026, then after having a picnic on 1st January, the petitioner was returning home on his motorcycle. At that time, informant was ready to hiding there, waiting to assault the petitioner. As soon as the petitioner reached in the front of the Jintu Gogoi house, the informant Durga Buru stuck.
This is the earlier case.
Is the earlier case.
Earlier case.
No, this is the present case Lordship. First case is there Lordship. On the same day,
Injury photographs is of whom?
petitioner Lordship. Medical reports also we are annexed Lordship.
He is in hospital now.
No, Lordship is judicial custody Lordship.
No, he was admitted or something.
Judicial
Get the
custody.
case diary and medical report with a
Yes.
short date.
Lordship, kindly allow the petitioner interim
Actually,
because
we
of
do not know.
nozzle fracture is there Lordship. Medical report also annexed Lordship. And we are lost also in the same day Lordship, we are lost FIR against the informant Lordship. Gugamuk Police registered a case as a Gugamuk PS case number 2/2026 Lordship.
Where is that FIR?
FIR page number Lordship 36 Lordship. Bhanikula FIR page number 36 Lordship. May I read Lordship?
Just this is the FIR against them.
Against the informant.
2/1/2026 at 15 hours. And the other one is at 2/1/2026, same date.
Same day Lordship.
Page 20, 36.
36 Lordship.
Must have been.
Maybe enmity is there between the it reflects, but my lord here.
Number of occasion Lordship threatening the informant. Threatening by the informant to the petitioner as well as his wife Lordship. Previous entities there Lordship. As on the behind the by 18 days Lordship. Special medical care also required Lordship.
Gugamuk PS case number 2. Right?
Two of
This is 1. shortly after this
Yes.
incident.
Both CD may be called for, my lord.
Both city can be called
Both
for
CD. And short date may be fixed, my lord.
short date. Yes.
At that time, my lordship, kindly.
Let us see the FIR. Let us see the case diary. Sorry. Hertzman. Call for the case diary of Gogamuk PS case number 1 of 2026, as well as the case diary of Gogamuk PS case number 2 of 2026, along with respective medical reports, if any. This is the matter on as short as possible.
Short date.
Friday.
Friday, yes.
Friday. Okay, we'll see. And
Lordship,
Friday will be 30th.
highly obliged.
Item number 7.
May I please, your lordship? Lordship, it's a regular bail application and for the last 60 days I am behind the bar. Lordship, may be pleased to peruse page number 17, there the FIR lies.
7.
Page number 17, madam.
The allegation.
So allegation is mainly about lending money. So here one SI of police, he lost an FIR. He says that I have the honor to report that I have made an inquiry today on 27/11/25 at around 3 hours. As per source information and as per above GD, reference that one Mongaluddin of village Khandarpur under Borbeda PS along with his son, Nazir Rahman, age 26 years, has been running an illegal money lending business from long time at exorbitant interest rates. It was also informed that they have a history of mentally and physically torturing the public in connection with such illegal money lending activities. They have been demanding and harassing various people with an interest up to 10% per month. Additionally, with conspiring to derive monetary benefit from all by sitting. During inquiry, SIUB Ujjwal Begu along with a WPC and available battalion staff proceeded to the house of the said accused at village Khandarpur. A house search was conducted in the presence of independent witness, namely so and so and so and so, during which the following articles were recovered and seized: 57 number check books, total 46 number blank pages with revenue ticket signature, 2 numbers of RC White registration number so and so and so and so, 2 numbers of ATM card White ATM number so and so and so and so, total 43 numbers of illegal money lending, namely Indian non-judicial stamp. During the house search, accused Mongaluddin was found absconding. However, his son Nazir Rahman was apprehended on the spot and brought to Borbeda police station for further interrogation and necessary legal action. So I am, my lord, Nazir Rahman before your lordship. So here, upon receipt of this FIR case is registered under section 112, subsection 2B, 35, 35 and 38, 308, subsection 4. So police now branded it as an organized crime. As 111, subsection 2 is there, my lord. So from the reading of the FIR, at the most, a prosecution may be drawn up under the Assam Moneylenders Act of 1934. And I brought the copy, my lord, as per the latest amendment also.
Latest amendment in money lending.
In 2022, my lord.
Money lending.
So the third page.
Money Lenders Act.
Yes. Third page amendment of section 12. Third page, my lord. In the Principal Act for section 12, the following shall be substituted, namely, whoever fails to comply with or acts in contravention of any provision of this act shall, if no specific penalty has been provided for in the act, be punishable for the first offence with fine, which may extend to rupees 30,000, and for the second and subsequent offence with fine, which may extend to rupees 60,000. So this is the punishment prescribed in the Moneylenders Act. And furthermore, my lord, the concept of economic offence that is there in section 111 of the BNS, it also doesn't fit here.
Can we get the case diary on Friday?
Yes.
Friday or earlier? Thursday?
Friday or
Tomorrow or
Friday.
Friday? Let me have a look at the DNS.
Yes,
Otherwise, going by the sentence of this is will be available offense.
Yes, my lord. For the first offence 30, for the second 60. Nothing is there, man.
Problem by lending at very high rates, but anyway,
308.
criminal offense, it has to be made out. It will be available and they're saying that it is.
And everything has been seized, my lord.
been so and so.
Nothing has to be recovered from my possession.
One, let me have a look, huh? They say it will be covered by one organized crime.
So, my lord, the economic offense that is given in explanation 3, it includes
Otherwise,
criminal,
theft, extortion, these two your own company, right?
yes, counterfeiting of currency notes doesn't come, bank notes and government
Definition
stamps,
of economic
hawala
offense.
transactions, mass marketing fraud, running any scheme to defraud several persons or doing any act in any manner. So how lending money can be to defraud people? If that is the basic allegation, my lord.
Economic offense.
No
Anyway,
case is
when
made
did
out
you get
under.
the case diary?
Yes,
I'll try to
get it on the
Thursday.
only.
Thursday,
Friday only.
Friday or Thursday? Third.
B Bora.
Learned Council has placed before me the latest amendment in the Assam Moneylenders Act. And the amendment made in section 12. And submits that the said offense would be bailable. He also submits that the offense of organized crime given by the investigating authority would not be attracted considering the ingredients of the allegations. Nevertheless, call for the case diary. Release the matter on Friday, you said.
Friday.
Let that copy may be kept in case record.
I'll keep it.
Yes. Obliged.
May I please, my lord?
Yes.
My lord, it's a regular bail application, my lord.
Yes.
Now, my lord, petitioner is in jail, my lord, 181 days, my lord. It's a charge sheeted case, my lord. Charges frame lordship, pays lordship 22.
Page 22.
May I read?
Yeah.
Srimati so-and-so, learned PP so-and-so, accused person, Sri Manovian, this present petitioner lordship is proceeded from the judicial custody, hard on the point charge, having they found the prima facie case against the accused person, submitted a charge under section 64M lordship. There's a charge under section 64M lordship is a repeatedly sexual offense, my lord. It's a punishment for rape lordship. And now lordship, the page 24 lordship.
Just 64. 64M.
Yes, lordship.
Have a look.
BNS lordship.
Earlier 376-2.
Yes, lordship.
64M. It's repeated same.
Rape repeatedly on the same woman. It's a this alleged victim. It's a married woman lordship. Can you see page 24? Page 24 lordship. This alleged victim itself, the self-declaration come affidavit lordship. Paragraph number 4 lordship. Page 25 lordship. That I therefore express my intention to withdraw my complaint and not pursue the said case any further lordship. Page 25, paragraph number 4. And lordship and surcited lordship. Page 20 lordship. It is the opinion of the doctor lordship. Page 20 lordship.
20.
Column number 22 lordship. The opinion of Dr. Lordship, column number 22 lordship. No sign of the sexual assault lordship. And now
What is
this
the age? She's major.
major lordship, it's a woman lordship. Married woman lordship. And now I'm in the jail lordship, 181 days lordship. And charges frame lordship. Nothing else, Lordship, as it is charge sheeted clearly mentioned. It's a bogus fact, Lordship. It's case, Lordship.
We'll verify the,
After finding material.
Yes, and now, Lordship, after 2 years, Lordship, this lost the FIR, Lordship. After 2 years, kindly see this FIR, Lord. Page number, Lordship. Page 10, Lordship. Page 10. The FIR lost date on 3/11/24, Lordship. May I read just 4 lines? Which reference the subject cited above, I understand hereby inform you that so Manavian, this present petitioner, so and so, residence of so and so, so and so, the intruded himself as a SBI so and so section assistant assured me to get KYCC loan in the year 2022, Lordship.
let him go on interim now, but the thing is that we'll get the record and IO should, how to verify this affidavit.
Kindly see, Lordship, this,
Otherwise, I will, yes, otherwise, my lord, finding materials against the search sheet submitted. Regarding at the time of framing charge, my lord, whether he has filed any discharge application, that application also need to be annexed.
kindly see, Lordship, this, kindly see this FIR bottom line, this Pinky Gohai, same signature. Kindly see page 10, this informant signature, Lordship.
That's okay.
Yes, signature is similar, Lordship, same, Lordship.
Regarding that affidavit, yes, my
Of
lord.
course, I trust you, but the thing is that just for this procedure,
Yes, Lord.
this thing, but the investigation is already over. So what
Yes,
you can do is you can submit the original before the IO or the court,
Yes,
and that can be,
yes,
sent
that can
along
be
with the case
verified.
diary, can be verified.
Yes.
And or she can come here to someone, if not personally, through someone, you can come. 483 bail application, BNSS, seeking bail with regard to Moran PS case number 98 of 2024. Which after completion of investigation resulting in a charge sheet, has been registered into Sessions case number 223 of 2025. Learned counsel drawing attention to the relevant order submits that on 29/11/25. Charge has been framed against the accused under section 64M of BNS. The gist of the allegations in the FIR dated 3/11/2024 is that the informant got to know the accused in 2022, and thereafter there was some and thereafter he transferred some personal photographs to his mobile and started blackmailing her. And that he also raped her several times. From the FIR, it appears that the informant is married with a son, and that her husband is also alive. Learned counsel has drawn my attention to a copy of an affidavit dated 31/7/25, purportedly made by the informant, stating that she intends to withdraw the complaint and decided not to pursue the case. We'll call for the case record.
Yes, my lord, scan copy.
Yes. Call for the scan TCR comprising the charge sheet, scan copy of the charge sheet and the case diary. How to get this affidavit? That's what I'm thinking, because it is not, the record has been submitted in the court, right?
Yes.
Oh.
Then I will have to send a copy of the petition along with the affidavit to the IO, my lord, in the present petition. my
So, original is with
Yes, Lord.
her,
Yes, I have.
lord. Now
with
you
her.
have,
original is with the lady.
Yes,
my lord, original is, my lord,
However, in the interim, the accused is allowed to go on bail of the accused who is in custody since 31/7/2025 is allowed to go on interim bail of rupees 30,000 with one security of the like amount to the satisfaction of the concerned learned court session judge Dibrugarh, I think. Session Judge Dibrugarh. And subject to the condition that he shall cooperate with the trial and he shall not in any manner intimidate, harass or harm the informed or a family member. Full stop.
Well, my lord, petitioner can also submit a copy of the petition along with the order of this honorable court to the
Yeah.
IO, my lord. It will be, my lord,
The petitioner shall submit a copy of the order of the copy of today's order along with the said affidavit. And the IO shall make necessary verification of the same and submit a report.
yes,
Submit a report.
on my lord. 17th of February,
17/2.
17th.
Deeply obliged.
Number 5, time being item 5. Time being item 4.
Yeah, my lord, with all respect, my lord. That Lasit Khana Borfukon case, sorry, yes, Lasit Khana case, my lord. Here, all other co-accused, to my knowledge, my lord, they have been granted the privilege of bail upon being charge seated, my lord. And these are the orders. May I just please it, my lord? অলপ সোনকাল কৰক।
Yes. Arising out of this incident.
Same case, my lord.
Yes.
Same case.
First for 1 to 4 paragraph slip, page 163. Stop. This is the subsequent bail petition. That an earlier bail petition was rejected on 18/12/2025.
During investigation.
Passed in BA 3989/2020. The land council Mahajan has submitted before the court, has submitted that most of the other coaches have already been granted bail on completion of investigation resulting in a charge sheet. Copies of the said orders. So copies of such orders passed in 5 bail petitions have been submitted before the court. And I have perused the same. So. It appears that upon completion of investigation, charge sheet by way of CS number 6978.
Yes, my lord.
6978 of 2025, dated
CS number 697/25.
697.
697/25.
Sorry,
dated 30/10.
He made a mistake. Sorry. Number cannot be so big. 697. Order 697, right?
697
Of
oblique
25, dated
30/10/25.
30/10/2025 has been submitted. Considering the completion of investigation and the aspect of parity, the present petitioner also allowed to go on bail of same condition. 50,000 with one civil, same conditions. Okay,
Highly obliged, my lord. Obliged. Obliged, my lord.
can I just keep it? I'll return.
Yes, yes, my lord.
I'll return it.
My
After
lord.
completing the order and
My lord.
this was.
Time being 1, 2, 3.
In this case, your lordship was pleased to reject it earlier, your
Oh, yeah.
lordship.
Investigation is not complete.
Lordship, 81 days now, your lordship. Page 42 is your lordship's order. Your
Is it?
At that moment, your lordship was
Yes.
of the opinion
Whatever it
that
is,
the
right, yeah,
investigation
yes.
should be allowed to
Submit reels.
carry down on the
Yes,
momentum, your lordship. Now, your lordship, 82 days has been passed, your lordship. 82 days.
Earlier bail.
And in fact, one of the co-accused has been granted bail, your lordship,
Okay.
on 65th days, your lordship. Probably further custodial detention is not required, your lordship, in this case. And in fact, your lordship, except 111 2B, rest of the offences are, your lordship, 60 days offence, your lordship. On the point of length of detention, similarly placed, earlier rejected. 81. 7 তারিখের হয়েছিল?
1711
When can we get the CD? Day after tomorrow? Should we get the CD?
yes,
update?
day after.
Lordship, I leave it to your lord. Only thing, your lordship, since your lordship
Yes, yes.
around
Only
82
update
days,
investigation and all.
Lordship.
That's but long. Significant time in custody. This was given on the basis of length of detention.
let us detention. I am also praying for that, your lordship. These boys are, your lordship, and two of the boys, your lordship, they are, your lordship, in fact, except Rontu Panipuan, other two, your lordship, young boys, your lordship, they are not leaders, your lordship,
Wait, so
of this organization.
right, earlier bail petition was rejected on 19/12/25 in BA 4076 of 25. Learned counsel, Mr. Bhattakumar, submits that is mainly on the length of detention and to support his contention, placed in order dated 9/1/26, passed by ordinance bench, granting bail to in BA 3974, granting bail to one co-accused. Mainly on the length of detention of 65 days. However, in that before after perusing case diary and mainly on the length of detention of 65 days. Case diary was there. It had come case diary the other day. Anyway, it was before this. So call for the updated case diary, this day after tomorrow.
Oh, day after.
Day after, dispose of.
Deeply obliged.
Yeah, tomorrow will be which date?
29.
29.
Deeply obliged.
Same order, 1, 2, 3. Same order,
All the three cases, your lordship.
same. It was a timely.
Next page, my lord. My lord, this is the second bail application, my lord, earlier rejected by your lordship, my lord. Till today, 79 days in custody, my lord. Arrested on 10/11, my lord. FIR against the petitioner is at page 30, my lord. 30. Earlier rejected mainly on the ground that investigation is going on, my lord.
I see.
3030, my lord. My lord, petitioner before your lordship is Miraj Ahmad, my lord. He is the owner of, my lord, e-rickshaw.
Acha, acha. Makum PS, right?
Makum PS.
It'll take some time to get the case diary.
79 days, my lord, and my lord, he is the owner, my lord, which the deceased was driving, my lord. What happened, my lord? There is a case of mob lynching, my lord.
Mhm.
Thereafter, he was arrested, he was sent to jail. My lord, from in jail, his condition deteriorated and he died, my lord.
Right.
Thereafter, this FIR was lodged, my lord. Several persons were arrested, including the petitioner. my lord.
4th or 5th February, my lord, I can.
Mhm.
4th or 5th February,
Next Monday,
next month.
third.
Second, my lord.
Tuesday would be convenient, my lord, Tuesday, 3rd of February,
Third of February.
3rd of February, because Sunday is, my lord, holiday, so on the next.
Page 34. Earlier bail petition was rejected on 18/12/2025 in BA 4025 of 2025. The Learned Counsel submits that the and the petitioner has already spent 72 days, 79 days study and 6 bail at this stage. Since there's a length of detention is there, let us, can it come on Friday?
Friday.
Today's Tuesday, still 5 days.
Friday, I can try, my lord.
You please try. Call for the updated case diary of Makum PS case number 50 of 2025. Please the matter on Friday.
Obliged.
30.
Obliged. Lordship, the sheeted trial started, my lord. At this stage, my lord, scan copy may be called. Arising out of session, special case number 4 of 25.
Homicide case.
My lord. Only on the basis of my lord,
Okay.
prime accused, my lord, he was arrested. At 15 days is behind the.
The petitioner was is in custody, judicial custody at present, and he was arrested on 15/8, 2025 in connection with Umrangsu PS case number 17 of 2025, which after completion of investigation has been charge sheeted under the provisions of BNS as well as the SC/ST Act, 1989. The case is stated to be at the stage of trial now.
Yes.
Call for the scanned copy of special sessions case number 4 of 2025, rising out of Umrangsu case from the court of the learned session judge.
Dimasa.
Dimahas,
Mile.
learned court of the learned session judge, Dimahas. This is the matter on,
19/2, my lord.
no, don't, please, there, let's see, I want to examine it
Yes,
the earlier. Next week,
next week,
That's
yes,
week.
on 5,
or Wednesday, next Wednesday,
yes.
next Wednesday.
Obliged.
4/2.
May I please, my lord? This is third time application, my lords. My lord, out of same incident, there are 2 FIR have been lost. The FIR lost by our side is registered as Kazigao PH case number 42 of 2025. And the FIR lost by the other side is registered as Kazigao PH case number 43 of 2025. The case, the FIR which has been lost by our side, that is charge sheeted already. So my humble submission, kindly call for a update case diary, my
This investigation is still going on as per your-
maybe this case may be charge sheeted.
learned counsel fairly submits that earlier bail application, one of that two earlier bail petitions were rejected by this court. With one of them on 8/9/2025 in AB 1760 of 25. Call for the updated case diary from the updated case diary of the concerned police station. Kazigao PS case number 43 of 2000. This is the matter.
On 9/2, my lord.
9/2. 9.
My lord. Okay, my lord.
Lanka. You'll do it or after something? After something.
My lord, this is a pre-arrest bail application, my lord. Lordship will find the FIR 141.
One.
Case 14, Lordship will find the FIR, my lord. May I read, my lord? Oh. My lord, with reference to the subject cited above, I have the honor to report that on 19/12/2025, at about 12:22 p.m., a credible information was received regarding flying of a black-colored vehicle within Jonai area, and registration certificate RC of the vehicle has been already cancelled by the RTO authority. Hence, it was suspected that the said vehicle might be involved in criminal activities with fake identity. Accordingly, I, along with staff, immediately rushed to the place towards it was seen and conducted a local inquiry. Upon the inquiry, we have detained the black-colored Hyundai Verna vehicle bearing registration number so and so at Raksin area, which was being driven by Madhav Soikia, son of so and so, resident of so and so. Upon being questioned, he failed to give any satisfactory reply and merely stated that he had purchased the said vehicle from one Sami, along with his associates Dhruvo and Bablu. On suspicion, the driver along with vehicle was brought to the police station for further verification. During verification, it was revealed that the said vehicle had earlier met with a serious accident and full insurance claim had already been settled, and registration certificate of the vehicle had been cancelled by RTO authority of Shivsagar. As per law, the engine and the chassis along with major parts of the vehicle were required to be disposed of, but same was illegally repaired and subsequently sold. The buyer knowingly and intentionally purchased the said vehicle despite having full knowledge that the vehicle was scrapped and its RC was cancelled. The above facts clearly disclose the commission of cognizable offences involving criminal conspiracy, cheating and personation, forgery, etc. Now, my lord, the petitioner before your lordship is not named in the FIR, but lordship will see kind of para 4, my lord. He has been continuously being called by the police, my lord. I have mentioned over phone to appear before them. And the person, my lord, who allegedly was driving the vehicle, Madhav Soikia, along with other two gentlemen, my lord, one Dhruvo and the other person, they were called to police station, they were allowed to go. Now, my lord, police is now calling me. I intend to cooperate, my lord. Kindly protect me, my lord. Otherwise, my lord, the fact is within the knowledge of.
After the claim was settled, the RC was cancelled.
My lord, probably
This I do not
vehicle,
understand.
my lord, vehicle that, my lord, why that, my lord, already vehicle was scrapped and this RC was already probably after damage, so vehicle was so badly damaged that it cannot be again, my lord,
Repaired.
revived for running in the road. So therefore, my lord, probably any such order was passed that vehicle was, my
And
lord,
the chassis and engine number of.
my lord, they should have, my lord, cut it into pieces and sold it, my lord.
Sold it.
But they again rebuilt.
Repaired in an.
Yes, my lord. So knowledge is, they are in fact aware about the set. I intend to
how
cooperate. I have no way connected, my lord.
You appear.
My lord, my lord.
Heard the petitioner and P. Thakur learned additional PP. Invoking 482 BNS, the petitioner is seeking anticipatory bail in connection with Jonai PS case number 104 of 25 in the section 20. Case arose out of an FIR dated 19 FIR dated 19/12/25.
My lord.
Full stop. Lost by police officer from the Jonai PS with the allegation that an information was received from people about one vehicle being driven without proper registration certificate. Full stop. Thereupon, an inquiry was made. A black colored Hyundai bearing registration number AS04 X5754 driven by one Madhav Soik, then upon questioning, he merely stated that vehicle was purchased from one Swami along with his associates, Ruba and Bablu. It is alleged that the vehicle had earlier met with a serious accident, whereupon the insurance claim was settled, and the vehicle was stated to was supposed to be disposed of as scrap. Full stop. The present petitioner is not named by the said name in the FIR. Call for the case diary, however, to enable the petitioner to record his version of events. It is directed that in the interim, the event office adds 25,000 funds to the satisfaction of the receiving authority, subject to the condition that he shall cooperate with the investigation, appear before the IO, making himself available for examination, shall not hamper or tamper with. This is the matter of
16 to 20.
16.
Deeply obliged. Obliged.
May I please, Lordship? My lord, this is second, my lord, application, my lord, under for PAS bail. Earlier was rejected by this whole court on 17/12/2025. That is page 28.
Oh.
Now, this second application, my lord, on the ground of the medical ailment, my lord, the petition number 1, Lordship, he was in fracture, my lord, page, my lord, 31 on 4/10/2025. But so far allegation is concerned, it was happened on FIR, my lord, page 13,
1410.
14. So prior to that, he was in fracture. So he cannot take part in the incident. This is my lord document. And his wife also in severe ailment, and as well as his son, my lord. He was associated with the entire family for medical ailment. Now, other relevant fact, my lord, so far petition number 2, son is concerned. He also in severe ailment, my lord, that is page, my lord, 38. Sohail Ahmed, he is the son of petition number 2. And he is also, my lord, I have narrated in my plan, my lord, detail. So, blood-related disease, my lord. And so far, petition number 3 is concerned, annexure 6, page 40, Jubair Ahmed, he is also some impression, my lord, here saying infection ceased involving. And so, my lord, on that ground, he was suffering since 7/3/2023. My lord, so on that ground, my lord, as other factual background, on the same day, petition number 1 lost cross affair. That is Lordship Patharakandi PS case number 230. And it was also called for in first application, but
Right.
it was not produced
Not
by
present.
this. Only, my lord, 229 was produced, and after perusal of 229, and without having a medical report so far, case number 230 is concerned, the bail was rejected, my lord. No, so my submission, my lord, kindly call for the CD of 229 along with 230. 23, my lord, it is our case, cross case,
Okay.
and bail application filed in 229. We are seeking bail 229, my lord. So in the meantime, my lord, humble submission, if on the basis of the medical ground, so till next date, my lord, returnable days, my lord, protection may be given.
Will it come on for Friday?
Friday, my lord, already. On Monday, my lord.
Monday will be safer.
Mon-
Can you wait Monday?
Monday.
Because he has recovered from the fracture or he's undergoing some treatment also. Fractures in a metacarpal bone.
And
Long time actually. Must have healed to some extent. Anyway,
fracture, my lord, and his wife also, my lord, in some blood-related disease, he cannot go abroad. Sorry, lordship, in out of station for better treatment because of this case. Because police is behind.
we'll dispose it of quickly. Just hold on. Monday will
Yes.
Uh,
The learned counsel submits that, fairly submits that an earlier bail petition was rejected by this court on so and so date. Hello, past in AB number. And so call for the updated case diary of Patharkandi PS case number 230 of 2025. Full stop. Also call for the
Lordship, we are seeking bail in 229.
this is the earlier one, no?
Yes, but,
229 of 229, no?
229.
229 of 2025. Within bracket, pertaining to the FIR lodged against the petitions.
Yes, Lord.
It's also call for the case diary of Patharkandi case, PS case number
230.
230 of 2025, within bracket, pertaining to FIR lost from the side of the petitions.
Petition number 1.
Petition number. Leave the matter on 222.
Along with Lordship medical report.
Along with medical, the respective medical reports may also, shall also be sent. List on 22. We'll dispose it.
I love
May please your lordship. Lordship will find the FIR at page 30, the type copy, translated copy law.
One.
Page 30.
38.
Which you may read. With due respect, I beg to state that today at around 6 p.m. on 12/1/26, when I was reversing my car on my way to Tezpur market from Junaki Port, I collided with a bike of the following person. When I got out of the car and asked him, the bike rider shouted on me using obscene languages and forcefully touched my private part. Then when my husband and father-in-law came to rescue me, both the bike rider, namely Iftikhar Hazarika, and several others came and beat my husband on the head with the intention of killing him, occurrence of which my husband and father-in-law got grievous injuries. After beating them, the bike riders and several persons left the place, and while leaving, they threatened us, saying that Hindu dominance won't work in this place, Hindu Adhipatya Nasolibo. But Lordship, the fact remains is that my brother at page 16 and 17, I have annexed this photograph where my elder brother was seriously injured by the informant's husband as well as father-in-law at page 16 and 17. And I am not named in the FIR. When I received that information that my brother was seriously injured by the informant, I immediately rushed to the Konakrata hospital, civil hospital, to attend him, Lordship. At about 7 p.m., I got the information. And I was in my workplace. I am not named in the FIR. Lordship may kindly protect me. I will appear before the IO and record my statement, Lordship.
Who is he?
He is not named in the FIR. He is the brother, younger brother of that person at page 16 and 17.
Iftikhar.
Yes, Lordship.
Elder brother.
If the petitioner's elder brother, aged about 55 years.
Okay.
Kindly protect me, Lordship. I will appear before the IO.
He is not named, but my lord, both the bike ride, namely Iftikhar Hazarika and several others, my lord, came
Yes.
in with my husband.
Yes. But I was not on the place of occurrence, Lordship.
On the head.
And is there a cross case or something?
Cross case, we have filed a FIR, but it was not received and not even registered.
Who assaulted?
That informant's husband and father-in-law by
They assaulted?
by helmet.
Sure.
And he was under treatment in the Konakrata hospital, and thereafter Lordship police has arrested him after he was released. They are at random, they are arresting Lordship. So I'll appear before the IO Lordship and I'll record my statement. Lordship may kindly.
Just a minute.
Otherwise, on Thursday, my lord, I can Thursday or. But. 3rd of February.
heard learned counsel for the petitioner and the Bhattakur learned additional plea. Invoking 482, the petitioner is seeking pre-arrest bail in connection with Tezpur PS case number 35 of 26 under section 7. The FIR is dated 12/1/2026, lodged by one Pooja Sharda Jain, with the allegation that on the said day in the evening, while she was parking her vehicle, collided with a bike of the FIR named person. And when she got out of the car, asking, bike rider shouted, the bike rider hurled obscenities upon her and also touched her private parts. Subsequently, when her husband and father-in-law came to rescue, the bike riders, Iftikhar Hazarika and others, came and beat her husband, injuring them. The FIR names Iftikhar Hazarika, Joyson Hazarika, stated to be his father, and 4, 5 several others. It is submitted that the petitioner is not at all connected with the alleged incident, and he was not at the place of occurrence as well. And he upon getting information about injuries caused to his elder brother by the husband and father-in-law of the informant, he came to the hospital to attend to his elder brother. It is submitted that he may be given an opportunity to record his statement with some interim protection. Call for the case diary along with medical report. Accepting the prayer of the petitioner counsel in this regard, it is directed that in the interim, 25,000 is once yearly, subject to the condition, shall cooperate with investigation, make himself available for examination. He shall not in any manner intimidate, harm, or harass the informant or her family members. This is the matter of
My lord, 16
case diary along with medical report.
16/1.
16.
Deeply obliged, Lordship.
Standing at inquiry.
Earlier it is arrested my second time. Earlier rejected my my only question is, though your lordship may not gotten married at this stage, but so far the main accused already arrested and already released on bail. On that ground I have come. By this time also investigation might have been completed. And so far petition number 3 is concerned, he is a student of my IS coaching. And he was not present, a certificate also given in support of his case. You were during that time, he was on library. Please go to ask him.
10, 12,
Yes.
last rejected.
Yes.
From the head. Should we get the
Charge sheet, my lord.
Yes, is there
No,
in the
not charge sheeted, my lord.
charge sheet?
No,
Not-
not charge.
The case diary one. File to authority.
That was side of. There are 9 copy.
IS secretary. Lonka PS, no, get the updated case diary,
Yes, ma'am.
charge sheet,
I'll get
must
the
be nearing
updated.
completion also.
Yes.
Then maybe possible to take another view. The learned senior counsel clearly submits that the earlier bail petition was rejected 10/12/2025 in AB 2740 of 20. It is submitted that one co-accused has been already granted bail. Nizamuddin, no,
No, my lord, his name is Asif,
co-accused.
petition number 3, my lord.
And
Oh, 3?
and with regard to petitioner number 3,
Yeah, 3
Riazuddin,
co-accused already got arrested and got bail, my lord.
it is submitted that it is submitted by taking recourse to a annex document that he's undergoing coaching at a he was in the premises and the same has been certified. Nevertheless, call for the updated case diary considering the elapse of time. List the matter on Friday.
What date might of the post?
Friday. I have no problem if it comes
On Monday, my lord.
day after tomorrow. You want it on
On Monday,
earlier than that,
Monday, 2nd of February.
second or Friday? Friday will it come?
Friday, my lord, if not comes again, would be on 2nd
You
or
want it this week?
Monday or my learned friend is it. Monday, Friday,
2nd of February. Follow it.
May I please, your lordship, my lord, herein, this bail application petitioner is arrested on 10/6/2025. And he is, till date, he is in the jail hazard.
My lord, this matter, my lord, already, my lord, it is part in hard, my lord. The question is that, my lord, only two things are there, my lord, 2 points. One is that, my lord, that is the, my lord, that is the accused petitioner's plea is that, my lord, that the house from where the, my lord, the contraband recover, it is not his house. That is the first contention. So, my lord, for that reason, my lord was pleased to call for the, my lord, the sketch map, my lord, in the earlier order.
This is
My
the
lord,
last
though we have received the, my lord, the recent, my lord, that is the TCR, my lord. But my lord, there, my lord, that part is not available. Secondly, my lord, there is another development is there. When, my lord, there is the UTP was there, my lord. He was sent to, my lord, West Bengal, Siliguri jail, my lord. Then, my lord, only the question is that for what reason, my lord, he was, my lord, sent to, my lord,
Not
West
clear.
Bengal jail.
Hmm.
My lord, for that reason, my lord, is because in the, my lord, order, that is the passed by the, my lord, that is the trial court, my lord, that is not reflected in detailed manner, whether the case related to NDPS or other matters. That is to find out only the thing. Then, my lord, on 2/12/2025, my lord was pleased to direct us, my lord, prosecution, to, my lord, call for a report regarding the
Oh,
details
yes.
of the case from the, my lord, superintendent of jail, Silsor, my lord. My lord, that report is awaited, my lord. So, in this juncture, my lord, we pray for a small accommodation, my lord. In the meanwhile, while, my lord, we will.
So
my
two
lord,
things are
submit that.
awaited, the report from Silchar.
Report is also awaited, and, my lord, there is the sketch map, my lord. That
Sketch map
part,
from
my
the
lord.
IO.
That part we didn't receive, my lord. Because, my lord, some, my lord, local witnesses, those who are, my lord, available, they
Is
stated
it commercial quantity?
commercial quantity, my lord. NDPS commercial quantity. So, my lord, we pray for a small accommodation, my lord. In the meanwhile, my lord, we will submit the report from the central.
The Mr. Boyso learned additional PP drawing attention to the pertinent previous orders in this regard. It's that report was called for from the learned superintendent of Central Jail Kasar regarding the petitioner, accused petitioner / UTP. Full stop and full stop. It is submitted that this case map of the place of occurrence, copy of this case map of the place of occurrence was also called for. It is submitted that both these documents are not available, not received as on today, and therefore the prosecution seeks an accommodation today. Prays for listing it on another date.
Whether, my lord, again, my lord, a report whether, my lord, sketch map is available, that is called, my lord.
Should I call?
Once ago, well, that can be, my lord. Otherwise, we will go by that only.
Issue of
report of-
this requisition to the
Only that part, my lord.
superintendent of Central Jail Kasar regarding the to submit a report regarding the present petitioner. What
That
report?
communication we will make, my lord.
Also, what
But, my
report?
lord, regarding the part of the, my lord, that is a sketch map,
Sketch
my lord.
map.
Because now it is the, my
That
lord.
will be sent from the court, I think.
Yes,
Is it?
my lord. Only that, my lord, whether it is available.
This is
a
not
report may be
necessary.
called for, my lord,
Hmm.
or if it is available, then they only send us the.
No,
sketch.
this from Central Jail Kasar, it is not necessary. Requisition.
From central jail, that is necessary, my
Necessary.
lord. That we will, my lord. From the.
Report regarding what he'll get confused. He may get confused.
Right.
Report regarding his whereabouts actually.
Yes, yes. Yes.
Should we say like that?
Yes, yes.
Report. That's why I hesitated. Report regarding the whereabouts and the present status of the petitioner, accused petitioner / UTP, namely so and so. Further, a copy of the case map may also be called for from the, which is the court, relevant court? Session judge, is it special judge? Kasar?
Special Judge Kachar, my lord.
Special judge, special judge, NDPS, Kasar. Pertaining to case number, kindly give me.
Silchar PS case number 603 of 2025, my lord.
That will also do. Pertaining to Silchar PS case number
603 of 2025.
603 of 2025. GR number is 1044. Can you cross check that?
GR number is my lord 1044 2025.
Zero- 1044 of 2025. This is the matter of
Any date, my lord.
after
2nd of February, my lord.
second, sir. If you can wait, no problem.
Any
It
date,
may
my
be on the 3rd of February, my lord. It is here, 3rd of February.
After a week,
It will take some time, so my lord. 3rd of February.
third we have to take some matters. Let it be on fourth.
Yes, my lord. Fourth, my lord.
No problem.
Completely obliged.
22.
In this case, my lord, I have filed an additional affidavit today.
Mhm.
The court has called for, but that may not come yet, my lord.
Just
After some time, my lord.
In this matter, my lord, CD of receipt, my lord.
Which one?
22, my item number 22.
Additional, CD has also not received.
Yes,
my
my
lord.
We'll fix another date.
My
Yes,
lord, my lord. Interim is
In the
there.
meantime,
Interim
we
is
will also
continuing, my lord.
the case diary not yet received, issue reminder. The additional affidavit filed by the petitioner side shall also be brought into the record. So, the interim bail granted by order dated 9/12/25 stands extended till the next date of listing. List the matter on.
17, my lord. 17 to
The case diary may be produced, my lord, on the next day.
Yeah, that's all. Issue fresh repeat. 17/2. 17/2.
24.
Wait, please, your lordship. Your lordship may kindly pass over this matter at timing and take it up at 2, my lord.
Right. After some second.
3:20.
55. Item number 25.
Lordship, kindly pass over a matter for timing.
26.
May I please, your Lordship? Lordship, the matter may be adjourned for the day as Mr. Kayal is not available today due to medical emergency, Lordship.
Okay. Learned counsel.
Lordship, standing counsel of NCB.
Oh, what happened?
He's having difficulty in walking, Lordship.
Lower court record is available, ma'am. Fellowship call for the lower court record last occasion is available.
Lordship may take this matter on 30th.
No, he's having some health problem.
30th of January.
I asked out of concern. So, 30. Learned counsel, getting on behalf of the standing council NCB seeks an accommodation and the learned standing council is stated to be unwell. Scan copy is already available. Please the matter on 30.
Highly open.
On that day, we'll see.
27.
Bad lordship. This is second application. Earlier it was rejected. Office note I could not see, lordship. Notice was issued to the restaurant, which is related to POXO case. And records were also called for.
Service report is, last office note is of 8/1. That service report is awaited, but
Service report awaited.
scan copy is received.
Receive, ma'am.
Otherwise, one of the new grounds is lordship, notice of arrest, ground of arrest.
Okay. See,
Arrest memo is at lordship.
can you take
My lord,
instruction?
it is the POXO, my lord. It is the
Can you
POXO.
take instruction?
My lord, my lord.
Regarding this,
Service,
note?
my lord.
I'll see I'll mark it,
My lord.
Yes.
just tag it. Which is the notice,
Notice was not Notice under section 47 was not given.
At page,
Only arrest memo is there, Lordship.
at page,
Uh, take my full apologies.
arrest memo. So bland. Arrest memo is also bland.
Yes, arrest memo is blank, sir.
47 is not given according to
Not
you,
given,
not given at all.
not given.
Anyway, that
My lord.
you can just cross
My
check
lord.
that also. The scan PCR has been received. However, service report upon the R2 respond number 2/informant not yet complete. The prosecution shall take instructions regarding
Ma'am.
the said service. The concerned police station. The learned petitioner counsel also submits that in the subsequent petition, one of the new grounds is taken is that no service, no notice under section 47 BNSS was given. So just for remembering,
Mine.
you also cross check it. List the matter on. You work out a date mutually.
My lord, 5th of February, my lord.
Okay for you.
God bless.
5-2.
No.
Yes, Lordship, scan copy was called for, my lord.
Charge sheet submitted,
Charge sheet submitted.
but commercial quantity.
Commercial quantity.
See,
FSL report, my lord, kindly be seen. And another ground, my lord, we have specifically taken, my lord, the 47 and 48 notice that was not furnished to the petitioner.
where at page,
My lord, page 5, para 6, that is one of the ground.
page 5, para 6.
Yeah. কিন্তু এই হেৰিত আপোনাৰ ফৰৱাৰ্ডিঙত উল্লেখ আছে কিন্তু সিহঁতক দিয়া নাই।
He was arrested on 24/7.
13/7,
13/7 and 24/7.
24.
Okay. So we have to cross check.
My lord.
You have to cross check since he has contended in para 6 that this is a press petition or subsequent.
Press.
You have to cross check.
My lord, in page 22, my lord, in their petition, my lord, last para, it was mentioned as enclosures, my lord.
That
Arrest
is there.
memo, inspection memo, notice 47 BNSS, notice 14 BSS, medical report. That is,
That is,
Page 23.
my lord, page 23 of the petition, my lord. Last line, my lord, enclosures.
Oh,
that is there, but I have
Okay.
stated also that in the forwarding report, though it has been mentioned,
but it is not there.
it is not.
We have to check from the
Mine,
record.
Lord.
Otherwise, we'll have to go to the merits
My lord.
and pass the test of 37.
But it was seized from their house, my lord.
Okay.
From the house of the
Apparently, I have not seen the notice. Can you have a look?
Right.
Just have, that's did it. I have not seen the notice. If necessary, we can take it up after some time.
my lord. After
Also-
some time. After some time.
After some time. So, they won't give it. Because he has to cross check. Just on first
Right.
glance, I have not noticed that. Otherwise, we'll have to call for because it refers
Right.
refers as an enclosure.
My lord, that's why, my lord.
Order first, arrow 1, 2, 3, same. Previous order, 8-1. Previous 1, 2, 3, and same. 3 to repeat with it. 3, 4, 2, 4. The case is stated to have been charged sheeted.
Right.
The learned counsel for the petitioner
Not here, my lord, তুমি call করো।
submits that
এখানে।
notice under 47 BNSS was not given at the time of arrest. However, he has also fairly pointed out that the ordering report dated 13/7/2025 mentions the said notices under 47/48 as part of the enclosures. The scan report has been received. However, I have not noticed that notice is not available in this compilation receipt. Therefore, issue a requisition to the learned trial court, that is the Court of Session Judge Gwalpara, right? Gwalpara, to send a copy of the notices under 47/48 and other arrest documents, if available in the main case report. Send scan copies of the from the main case. Will this be sufficient to determine, or should we ask for a, because
My lord, just my lord, the charge sheet submitted here, my lord, on the 3/12/2025 only, my lord.
case diary contains your need,
Content there, some portion is
Some
there, my lord. My lord.
since determination as under section 37 NDPS has to be made, therefore the learned trial court is also requested to send scan copy of the case diary and charge sheet.
Right.
And other relevant documents.
Right.
Let them send it
Right.
again.
My lord.
Something may be left out.
My lord.
Please the matter on
10th of February, my
10/2.
Right.
That's all.
published. None of it. Scan copy দিছি।
After some time, we'll
Right.
Bit.
Heading 31.
Mr. Derry.
May please, your lordship. In this case, your lordship, I was an interim
Hmm.
and I had already given my statement before the investigating officer.
Okay.
Your lordship, the FIR is at phase 14. The
Page 14.
14, your lordship. May I read?
Hmm.
I'm writing to formally lodge a complaint regarding the disappearance of a vehicle bearing registration number so and so. The same vehicle was loaded with 1,500 cartons of Ruchi Gold Palmolin, 770 grams pouches from the Adara yard on 1st June 2025 and was destined for Propeta Road. The consignment was booked to broker Niru Jain and was meant for delivery to the following parties: Anurag Agencies, 1,100 cartons; Ganesh Mill, 200 cartons; Sudhir Chandra Saha, 200 cartons. The vehicle did not reach the intended destination on 2nd June 2025 and has been untraceable
That is
since it left Azara yard. All attempts to contact the driver and the vehicle owner, Mafidul Islam, have failed as both their phones have remained switched off since the morning on 2nd of June 2025. This matter is of grave concern due to the high value of the consignment and the potential for misapprehension of theft. Your Lordship, the allegation is of theft. I was the broker, Your Lordship.
Broker.
I was the broker. I was the person, the I have no role whatsoever, your lordship. The driver and the owner are
Hmm.
both missing, your lordship. And that is why I was given the protection, your lordship. I have given my statement before the investigating officer.
Yes, my lord, she appeared, my lord, he appeared, statement recorded. And my lord, from the case diary, my lord, I have found police also arrested some of the accused persons, my lord. Nowhere, my lord, I have found but any of the accused person named the present petitioner. He
Fair enough.
appeared and cooperated with the
Very good, fair
investigation.
enough. Mr. T. Deori, Land Counsel for the petitioner, and P. Watakur Lanet, additional PP for the state. State. আপনি 2-3 হেনকে উঠাই দিব পাৰিব 1 2 3 4 previous order. The petitioner was granted interim bail on 22/7/2025. It is submitted by the learned counsel for the petitioner that the petitioner, as part of our business, was a broker regarding the transportation of the goods and is in no way related to the, is in no way connected with the allegations of the disappearance of the goods on the way. Full stop. It is also submitted that pursuant to grant of interim, she appeared before the IO and her statement has been recorded. Full stop. The same has been confirmed by the prosecution, and the learned additional PP also fairly submits that the investigation has not implicated the petitioner as well. In the given facts and circumstances, the interim bail granted to her stands is hereby made absolute, subject to the condition she shall continue rendering her cooperation to the investigation. Return back the case there.
Your lordship, it is a he, not a she, your lord.
He,
He, your lordship. He's a he, your lord.
Niru, oh, no,
The name itself is fine.
no,
I'm very grateful, your lord.
no, she. He,
My lord, here CD notice, my lord, they are in interim, my lord.
stand. Yes, there is stated to be not received. Issue reminder for the same. The interim order by 21/7 and continue till the next date of listing. List on
My lord, 18th, my lord.
18/2.
18th, my lord.
Barry,
Not received.
not received.
My lord. CD notice, my
Not
lord,
received.
yeah.
Same order. Interim order dated 11/8, right?
Yes, sir.
This
Uh,
also you. Yeah. Any suggested date?
My
You
lord.
have any preferred
Yeah,
date?
you- my lord. 18th, my lord. 18th, my lord.
Okay.
18th,
Okay. 18/2.
18th.
They are connected.
Okay, 36, 37, 38.
So, 31.
Forty-one. 41. What one, my lord?
After some time or
My lord.
diary has been.
My lord, diary not my lord, report was there, my lord, part in the record, my lord. That report, my lord. 41.
There's a report regarding notice. We'll wait for that.
No.
This report was reflected in the earlier order. Also.
My lord, in our petition also it has said that reports in the court records, my lord. Perhaps
It is there, it's reflected in the order.
Right.
Anyway, you know which matter?
Your lordship, in the last item 33,
33, yes.
yes, lordship, interim to be continued.
Yeah, I think we have said that already. I'll cross check it for you.
Yes, lordship.
Item 33. Yeah,
My sure.
it is said.
42.
Please, your lordship, could this be taken up after some time, your lordship? Say, AK Bhaiya will appear in this matter.
Additional affidavit has come into the record.
Yes, your lordship. Obliged, lordship.
43.
43.
42.
Maybe.
43. 43. In 43, charge sheet submitted, man.
Interim is also there.
Interim is there. 1812.
Is the allegation?
Allegation is your lordship, theft in a dwelling house, my lord, or ornaments, my lord. Ornaments were worth
Serious.
30 lakhs.
My lord, 331-4-305 is there, my lord. 3172. Yes, sir, dear, my lord.
The incident took place in Jorhat, my lord. I stay in Nagaon, my lord. I was served with a 35 notice, my lord. So that was the apprehension, my lord. And your lordship was pleased to run the interim on that. I appeared, my lord. My statement is recorded.
His marriage was there and
Marriage
he
was-
was not named in the FIR.
My
So
lord.
that's why this interim was granted. Interim was granted. Do you have the case there?
No, my lord, charge sheet submitted in this.
The charge sheet.
Right.
So should we make it absolute? But the allegations are a bit serious.
Let him appear, my lord, before the court below, my lord. Charge sheet submitted, my lord.
But this will have to be disposed of, right?
My lord. Then the court below will consider, my lord.
Is a section under dacoity given?
Not dacoity, your lordship.
Robbery.
Theft, my lord. Theft.
Then you
Theft, my lord.
you can get bail also.
Lordship.
For it. 18/12/2025 for allegations. On 18/12/2025, the petitioner was granted interim bail for the reason stated in para 6 thereof, within bracket, not being named in the FIR and marriage of the petitioner. Bracket close. It is submitted that in the meantime, upon completion, it is submitted by the prosecution that in the meantime, upon completion of investigation, the case, completion of investigation, charge sheet has been submitted against whom?
Against him also.
Against, charge sheet has been submitted
Against the present petitioner.
against the, including against the present petitioner as well.
Right.
In view of the same, the incident bail petition is disposed of with the direction that the petitioner shall appear before the learned court below and seek regular bail, which shall be considered and disposed of, comma, needless to say, comma, in accordance with law.
My lord.
And also keeping in mind the stage of the case. Till then, the interim order can extend. This can also be one kind of order. Here. 43. This was
1942.
May it please your lordship. 438 application, my lord. I was I was granted pre-arrest bail, my lord, interim, my lord. Thereafter, I visited the police station several times, my lord, and they will stated by way of an additional affidavit, my lord, I have stated that. Lastly, they have stated that they will inform me if required. Now they have not called me out.
Okay.
Now it's a civil dispute which has been given a criminal color, wherein my lord, after hearing me on the interim, my lord was pleased to grant me interim, my lord.
So his statement could not be recorded.
No, my lord, because they will say, they stated that they will call me out.
If
They
necessary.
didn't know. I went several times, my lord.
Also,
And the IO in the meantime got changed also. আছে record করিলে
record
হবে।
করুন. In the meantime, record.
My lord, statement recorded, my lord. My lord. Received the CD, my lord, but my lord, that is the police, my lord, filed one, my lord, that is the bail objection, my lord, in this case.
Okay.
Yes. The case regarding, my lord, that is the, my lord, monetary transaction, my lord, where, my lord, the accused petitioner, who is a, my lord, special power of attorney holder, my lord. My lord, the thing is that, my lord, that there is one firm, my lord, who is now the present accused petitioner is a special power of attorney holder. They, my lord, got some work from the PWD department, my lord, three works, my lord. And my lord, the allegation is that, my lord, that is, my lord, he did, my lord, fraud with the, my lord, that is the proprietor of the firm. And my lord, without informing, he opened another bank account in Federal
He's
Bank, my lord.
the power of attorney holder of that firm.
Yes, my lord. Now, my lord, and my lord, my lord, that money, an amount of 1 crore or something, my lord, that was, my lord, transferred, my lord. That is the allegation that, my lord, by means of fraud, my lord, that allegation is that, my lord, that is the bank of account was opened, my lord. So, my lord, during the course of investigation, my lord, police, my lord, seized some documents, my lord, here in this case, my lord. And my lord, that is from the, my lord, after interrogation and taking some, my lord, documents, they, my lord, seized one agreement also. That is, my lord, that is the power of attorney is 2018, my lord. And my lord, that is the agreement, that is the seize is 2013, my lord. After that is the special power of attorney.
2013 is?
2013 is the, my lord, that is the agreement, my lord.
Agreement.
After the power of attorney, my lord.
Okay.
And related to these works, my lord. I have flag mark all these things, my lord. And my first kindly peruse the, my lord, their objection, they categorically stated. And then earlier, my lord, this, my lord, matter was, my lord, registered under section 406, 420, 465, 468, and 120D of IPC, my lord. Newly added section, my lord, 403 and 409 of IPC, my lord. They made a prayer, my lord. Thereafter, my lord, that is the JMHC, my lord, that is added that, my lord. All these things are, my lord, there, my lord. Otherwise, my lord, that transaction part is there. Huh?
Public servant.
Yes, my lord. My lord, they are, my lord, now during the course of investigation, this, my lord, found that, my lord, there is some interlink with the PW, some officials or some employees of PWD, and same time, some people of the, my lord, that is the Federal Bank, my lord, where, my lord, that, my lord, another bank account was opened, my lord. That is the thing. And secondly, my lord, their contention is that, my lord, when they verify, my lord, that is the document, my lord, bank account opening form, my lord, they find, my lord, some, my lord, that is the signature, which is, my lord, used by, my lord, this is yeah, by means of, my lord, fraud, and, my lord, some was omitted, my some parts. That is the case. And for that reason, my lord, their prayer is that, my lord, at this stage, my lord, if my lord was pleased to grant the bill, my lord.
My case is very simple, my lord. Learned PP has rightly said whatever is in the case diary. My case is very simple, my lord. Now, by way of an agreement, which I have made part of the record at page 20, my lord, agreement has been entered into that all execution of the work will be done by the particular
On
petitioner.
behalf of Sushil Khandelia.
My lord, the petitioner, my lord, Manoj Kumar Halalka.
Yeah.
Yes, and the another person in this is the Sri Ganesh Trading Company represented by Sushil Khandela.
Right.
Now, my lord will kindly see, he is a resident of Jagir Road. And he comes and files an FIR in Sanmari police station. And we have categorically stated that his friend has been a police officer there. And so
I apprehend that foul play will be there, and that's why I approached this honorable court. Now, on this very basis, the work order are the same. Now, I intend to get 33% as per this agreement itself at page 20 of my anticipatory bail application. He doesn't pay for it. So I stopped work. And thereafter, what happened, my lord? He himself opened his bank account. Now, whenever bank account is opened, my lord, the PAN card, Aadhaar card, apart from that, every address has to be given. Address has been provided with regard to Jagi Road. Now, with regard to ATM cards and checkbooks, my lord, it is always the banking rules that checkbooks are sent to the address's house. So these are the check who, in the affair, it has been alleged to be misappropriated, is been sent to his house, and he issued not only to me, to other persons also. And on that very basis, my lord, with regard to this, he has lost this affair in Sanmari police station. So what I am on, my lord, here I made myself available before the investigating officer several times. My lord, till date, my lord, my specimen writing is not been taken. Why? Because the bank account that has been opened, my lord, is been a genuine one. Because it is his signature, his address at Jagi Road. And that my phone number is also there, being a business partner, and his phone number is also there in business partner. And so far PWD is concerned, in BTC area is concerned, my lord, absolutely nothing. Work order was given to them. And thereafter, on his instruction to the PWD department, that money will enter this account. So money has entered. Accordingly, he has, against his liability, existing liability, he has paid the amount. Now he cannot do anything, my lord. And as such, he filed this case, my lord, because he doesn't want to give me my 33% share. And that's all, my lord. It's altogether a civil dispute which has been given a criminal color, my lord. Because there are no question of forgery, my lord. Here in this case, we'll kindly see, my lord. Because for forgery, proving that I have forged his signature, his specimen writings, my writings, the question documents, admitted writing is required to be sent to the FSL. Nothing has been done by the police. Why? Because these are genuine documents.
Record your part dictation. Rest I will do it. First, last order to 812. Take two. And four. On 8/12/2025, the petitioner was granted interim pre-arrest bail. It is submitted by the Mr. Bhuya learned that he has pursuant to grant of interim, he has made himself available before the IO on more than one occasion. So the case diary has been received, and it is confirmed by the learned additional PP that the statement of the petitioner has been recorded in the meantime. A bail objection has also been filed by the IO, objecting to grant of bail. Mr. Bhuya, learned counsel, reiterates that the dispute is primarily a civil dispute, which has been given a color of a criminal case. It is stated that it is submitted that in terms of the agreement dated 27/2/2013, the petitioner was supposed to get 33% of the profit of the works undertaking on behalf of the informant, but the same has not been given to him, and that is one of the disputes. Full stop. It is also submitted that the relevant documents have not been sent to FSL, and his handwriting sample has also not been taken. And in this context, it is submitted that all the documents are genuine, and he has not committed any fraud or forgery with regard to the documents. I have considered the submission on the learned additional PP draws attention to the bail objection and the materials revealed by the investigation. I have considered the submissions, and Here is the relevant methods. Chamber. I'll go through it a little bit. My bad. Course of
Public.
beyond secret.
And the offense are punishable by 7 years. I have complied with it, my lord.
Okay.
Anything is there, my lord, I'll face the criminal trial, my lord.
It is also submitted by the land petitioner, counsel, Mr. Bhuya, that
That is what put over, my lord.
all the
Specimen-
earliest offences are punishable up to 7 years.
Obliged, my lord. Huh?
44.
My lord, here, we have received a CD my lord, but not up to date, my lord. It was earlier rejected, my lord, after going to the record, my lord, case there, my lord. And today we have not received the up to date CD, my lord. It is earlier, my lord, that is up to, my lord, 8/9/2025. That's up, earlier rejected.
Champa. Earlier bail petition was rejected on 30/10/2025. AB 2461 of 25. So, submitted by learned additional CP that though case diary has been received, but the same is not up to date. You want to
Mine.
send it back?
My lord, we'll have to send.
It will require updation.
My lord.
Accordingly, the case diary of Somoguri PS case 166 of 25.
Mine.
He returned back and procured again with the up-to-date investigation.
My lord.
Next time, maybe.
17th, my lord. 17th.
Short date may give your lordship.
Yeah.
Earlier it was rejected second.
Give it if possible.
My lord.
You can give it earlier also if possible. But the only thing is that exercise should be completed
My lord.
without much delay. Of course.
My lord. 17th.
No,
Seven.
you want it
Seven.
earlier,
1 second.
little earlier.
7.
Give him a little earlier.
12, my lord. 12.
Okay,
12.
okay,
Okay.
12.
Standing at 41.
41.
Yes. Lordship, interim relief was provided in this case, my lord. And as per our instruction, my lord, already case has been surseated. And on my lord, 12th is the next day, 12th February is the date for appearance, my lord.
That is the information.
We have no any information, my lord, at present, my lord. Whether
Someone-
such,
someone-
oh, my lord, they have received someone else from the court. That means,
The petitioner was granted interim bail on 24/11/2022. Mr. Chaudhary, learned counsel submits that as per definite information, the case has been charge sheet and reached the stage of appearance by PRC number 7 of 2026. And the petitioner has also received summons from the
Fine.
court for appearance on 12/2/2026. A copy of the said summons has been produced before the court. We dispose it of the
my lord.
produced before the court. Peruse the said. He appeared, could he appear before the IOI?
Yes, my lord.
It is submitted that pursuant to grant of interim, the petitioner also appeared before the investigating officer during the investigation. In view of the completion of, in view of the definite information regarding the completion of investigation and the case reaching the stage of appearance, perhaps it is not necessary to cancel the interim bail. Good stop. Accordingly, the interim pre-arrest bail granted by order dated 24/11/25 is hereby made absolute, subject to the condition that the petitioner shall be available for the trial, shall not hamper or temper defense, shall not cause any harm or intimidation to the witnesses or informants. You know, I could have 1, 2, 3. 2, 3. I'll keep this in the record.
Yes, my lord. Always,
This
Lordship.
post.
না না আপনি কিন্তু
May it please your lord. The petitioner is on interim lordship. As per my instruction, he appeared before the investigating officer lordship.
With an
Earlier-
injection,
my lord 45 and
Earlier-
47 my lord same CD my lord
45 and 47.
45 and 47. One is the owner of the pharmacy. and
Injection.
one-
That
yes,
injection case.
injection, unfortunately.
Yeah, earlier also he appeared, now also he appeared lordship after the interim order. And FIR lordship will find page 18
I remember, it's reflected also.
lordship. And in fact, those documents, CCTV footage was there, he was not present lordship, that page 23, that seizure list is there. CCTV footage seized. At the relevant point, he was not there. And second thing, your lordship will find that page 25, some documents relating to the pharmacy was seized from him. So police did not arrest him in that initial stage also. He was all along cooperating with the investigation.
Diary has been received.
Case they received my lord regarding the final opinion regarding cause of death also available in the CD, and their statement is also available in the case diary my lord. My lord, one is the my lord owner my lord, item number 45
45.
of the pharmacy, and second is the my lord the employee of that pharmacy my lord, who pushed the injection my lord.
What
And
happened
here from the this is the my lord final opinion as per my lord
Who's the injection in good faith or
my lord, yes, my lord, he in fact admitted in item number 47 in one of the paragraph, my lord. And regarding my lord cause of death, although my lord last portion, my lord. However, the histopathology reports of the lung tissues suggest death may be due to pulmonary causes. That is the report, my lord.
respiratory failure?
Pulmonary, yes, my lord,
Sudden respiratory failure.
yes. Otherwise, this accused person appeared statement.
Otherwise,
recorded.
it can, you know,
Statement
okay,
record.
that's okay. But such death can take place maybe due to, suppose is there anything to show that the medicines were counterfeit?
Regarding medicine of those my lord, expiry, my lord, those regarding that medicine, that is not there, my lord, regarding counter.
That page
Fake
23
medicine.
is there, expiry date is there, lordship, all those things are mentioned. There. They are within time.
Beyond expiry, it's usually, it may cause some damage, but usually it is, usually even if someone takes a medicine beyond
Medicines
expiry,
were
it may
not
cause death like that.
Medicines were not expired, but only difficulty is that they were supposed to take up that medicine in the FRU, but my lord, that is the.
Anyway.
Otherwise, he is the owner of the pharmacy, my
Yes.
lord, item number 45.
Mm.
And
Should I see that in
yes, your
cause of
lordship may
death?
kindly.
Page, page bottom, yeah? 45, and 1, 2, 3. Say, the petitioner was granted interim bail on 6/1/26. It is submitted that even earlier also and after getting interim bail as well, the petitioner made himself available for examination. Some documents were also stated to have been seized from petitioner. The case diary has been received and the prosecution confirms that the statement in the petitioner has also been recorded during the investigation and after grant of interim bail. Respiratory failure, that's okay, but how it's related to the
Regarding my lord, item number 47, paragraph 11, my lord, of the petition.
pulmonary causes? The opinion dated date, opinion regarding cause of death is stated available in the case diary. It is stated that the same final opinion could not be given due to non-receipt of the viscera report. However, the histopathology report of the lung tissue suggests that death may be due to pulmonary causes. It is submitted by the prosecution that from the investigation, it is not noticed that the injections in questions were counterfeit. Stop. What he has said in the statement.
Statement, my lord. Yes, I have, my lord, trademarked the statement of the owner, my lord. He is the owner, he is the owner of the pharmacy, and my lord, the item number 14, he is the employee of that pharmacy, my lord. And that is the, that he is the, and he is working in that pharmacy since last 25 years. That is, and his statement is also there.
The
He
statement
got,
of the-
he got the training for injection, that is from the,
The statement of the petitioner has been recorded as revealed by the case diary. There is some indication in the investigating material that there might have been some overdoses of the said injection at the time of administering it, which might be the cause of the death. Nevertheless, seeing the progress of investigation, the cooperation rendered by the petitioner to the investigation pursuant to grant of interim bail, dash at the time of the considered due that despite the bail objection, it may not be necessary to cancel the interim bail granted earlier. Accordingly, the interim bail is made absolute, subject to the condition that they shall continue cooperating with the investigation, shall not hamper or tamper with evidence, shall not cause any harm, intimidation or harassment to witnesses or the informants. Return back the case there. This is also similar.
Same, my lord, I am the employee, my lord, I am the one who had given the injection, my lord. We have no reason to hide it, my lord. We have admitted that we are the ones
Similar.
who gave the injection.
There's some indication that there might have been some overdose, but that has to be medically also proved. That has to be, but
One of
I
the,
always said,
one of the fallouts of rabies is also, my lord, pulmonary failure, my lord. I've checked, my lord. One of the fallouts of rabies is also, my lord, pulmonary failure.
Okay.
So that is also there.
Rabies can cause pulmonary
Yes,
failure.
Because this victim was bitten long back. Right. Deeply operated. Same conditions, my lord.
Same condition. আর এক মিনিট এটা হেঁটে করলো এটা হেঁটে করলো যদি সকাল মানে রিপোর্টের একদিন left over.
36, 37, 38.
Please, your lordship. Today is the fix for our filing objection and for a report by the police, lordship. I could not go through whether police has submitted the report on the alleged violation by condition, but we have prepared our objection but could not furnish to the registry because it could not furnish to the objector, whether objector informant the bail objector or informant lordship. He is not present here also. As such, rest is not accepting this.
Interim bail is there.
Lordship, interim bail is there, Lordship,
Interim bail is
and all other charge sheet has been submitted, Lordship. After submission of charge sheet, your Lordship has considered our bail, Lordship. And so for my information and instruction is there, the other 6 non-FIR named accused, FIR named but non-charge sheeted.
Not charged.
Trial court has already granted absolute bail to them, Lordship.
Obviously.
And Sessions case has been registered, is most probably fixed for evidence also, Lordship. So for the charge sheeted 9 persons only, Lord.
This is, which one should I take up first? 34.
My lord, 35, 36, 37, 38, my lord. Here, all the same, my lord, same FIR, my lord, same
GRO.
record, my lord. But here is the, my lord, in the last occasion, perhaps, my lord, informant was present, my lord. They filed their objection also.
Yes, yes.
And
They
in
filed
that,
an objection.
in that last order, lord, last order, it was
Yeah, it
reflected,
seems so.
it was reflected that they will file their objection, my lord.
I have prepared it, Lordship, but could
And
not
copy-
serve the copies to
Learned
them.
counsel
That's why
informed.
registry is not accepting. I have served the
What,
copies to
not
PP,
application
office of the
of the
PP.
Been pressurized.
Nobody is.
Draw the kids. They liberty
Release
file
nobody
an
knows.
Then,
You can take it up after 2 days. Maybe.
oh, my lord, then they will have to serve their copy, my lord. They
Because
filed,
we could not locate that lawyer.
Counsel.
phone number is there. Phone number
And
is there.
of-
Wakalat number. Phone number, India wakalat number.
I have to check it.
India wakalat number, there is phone number.
Informant, yes. And number is, enrollment number is there.
My lord.
The
First phone number is also there in the wakalat.
number is, I am not finding informant.
Most probably they are not interested in objection with their objections, Lordship.
Oh, since you have prepared your reply. Right.
I have prepared my
Yeah.
reply, Lordship. I have submitted one copy to the office of the.
Should we take it up day after tomorrow? Or
AG,
tomorrow
Lordship, or say a week, Lordship, because
Next week, my lord, then they will have to serve their copy.
No, I
After
definitely,
they will
Lordship,
file
try my best,
their reply.
Monday?
AG,
Same, no? In same.
Same, my lord.
Same, all.
34, 35, 36, 37,
order.
38, my lord.
Same order.
Uh,
Yes, sir.
It appears that as reflected in last order dated 18/12/2025, the informant side appeared through learned counsel and Hawk and filed a written objection. Good stuff. It is submitted by Mr. Poddar, learned counsel for the petitioner that the petitioner side has prepared a reply to the said objection of the informant, and it is in the process of being filed. Diary has been,
My lord, scan copy, my lord. This charge sheet.
scan copies has already been received.
Received, scan copy received, my lord.
Received, full stop. Let the reply be filed and brought into the record. In interim bail stands, interim bail granted by the order dated 25/11 for all the four, huh?
Yeah, Lordship.
25/11/2025 stands extended till the next date of listing. List on Monday,
My lord, 2-2.
2/2/2.
2-2.
Lordship, another order was there on the last order, calling for a report from police, Lordship, whether it has been arrived or not, Lordship, I am not sure, Lordship.
For a report.
When police there, because they have filed one complaint before police.
Nice, nice.
That is the basis of their.
Violation of
objection.
bail conditions, no?
Yes, Lordship, that is totally false. But they have filed one FIR, that complaint.
I
It was-
shall verify the matter and submit a report regarding
Right.
allegation of bail conditions. I don't know whether it will be in the, you have received
No,
something?
no, my lord, perhaps it
Uh,
will come through registry, my.
It is fairly pointed out by Mr. Poddar, learned petitioner counsel, that there was a direction in the last order to the IO about verifying an allegation of violation of bail conditions. But it appears that the report has not been, report is not yet available. The issue, you can take instructions, or can you, issue a reminder?
Right.
Issue a reminder to the IO to submit a report regarding the alleged violation of bail conditions by the petition. Eighteen 12 is, okay, it's a common order. This is not there. Okay. You want a copy of this order?
My lord, my lord,
A copy of this order shall be furnished to the prosecution for information and needful.
my lord,
List on 2-2. Okay,
my lord.
interim shall stand explained.
46,
Oblige.
May please your lordship, anticipatory bail application, my lord. We are in interim, my lord. And CD is called for with medical report, my lord. For the
Is they received, my lord?
And after getting interim protections, my lord, we appeared before the IO, my lord. An allegation is about group clash, my lord.
Group clash.
Yes, my lord, and the FIR on which we are seeking bail is a cross case of an FIR which was filed by from our side, my lord. And except the petitioner, my lord, other already get absolute bail from the subordinate court below, my lord. And
Yes.
Well, I have received only one injury report of one Rafiqul Islam, my lord. Regarding other persons, my lord, I have there, my lord, as per the FIR, my lord, 4 persons injured, my lord. One Shah Ali, Rabiul Awal, Sukul Ali, and Rafiqul Islam.
We have
Where
received
as
from
per the, my lord, from GMC, is, my lord, medical report, simple from nature of injury, my lord, simple from surgery side. Final report to be collected from Department of Ophthalmology. My lord, that final
simple from what side?
from ophthalmol,
No, simple from
simple from surgery side, my lord.
surgery.
Yes, your lordship may kindly
Surgery side. Don't know, they meant medically what it is they're trying to say very clear. So it's what a fight, huh? Mutual fight.
After obtaining interim petitioners appeared.
no, we appeared, my lord.
Fracture of
Right side, my lord, nature of injury.
injuries there. Of consciousness of sharp object. One. They recorded their statement.
Is set, my lord.
The petitioners were granted
Stated about family disputes between them.
were granted interim bail on 8/1/2026, pursuant to which they are stated to have appeared before the IO and their statements recorded. The same is confirmed by the prosecution, and the case diary has also been received. The medical report of one Rafiqul Islam is available, which indicates some injuries, and nature of the injury is mentioned as surgery from simple from surgery side. I don't know what it means actually. Anyway. It appears that there was a mutual fight in the context of family dispute. In view of the cooperation rendered by the petitioners and the progress of investigation that I have noticed, it may not be necessary to cancel the interim bail. Accordingly, the interim bail is hereby made absolute, subject to the condition that they shall cooperate with remaining investigation, shall not hamper or temper duties. shall maintain peace and shall not commit any illegal activities or offences. They shall not influence or harass, intimidate any witnesses or the informant side. Written by the case diary, disposed. Highly obliged.
48, 49.
Lordship, I am for the petitioner in 48. Here, Lordship, this is a search-sheeted case, and your Lordship has granted an interim protection.
Mhm.
And in view of that, he has appeared before the committal magistrate. It is in the committal stage now. So he has appeared before the committal magistrate, and his bail bond has already been accepted.
Scan copy of PCR not yet received. Oh, scan copy received.
Right, but wrongly sent. Lordship, the record furnished from the learned court below, my lord, it is wrongly come. It is from special Pokto Shivsagar, but it has to come from SDGMS Kamrup Metro.
Oh, they must put
Lord-
while sending might have mixed.
Lord,
Or this record might have come.
Yes.
It is with the registry.
Yes.
So shall we ask them to check up once
Yes.
or issue fresh requisition?
Yes. Your Lordship may issue press.
Probably the record has come
If-
because when I
If
went
my
the-
available in the registry, my lord, then your Lordship may registry may verify, my lord. If available.
probably the record has come.
Come, no?
Because I went to there to give the bail bond.
Yeah.
At that point of time, they have said that the record has already went to the High Court.
Must have sent. The petitioner was granted interim bail on 9/1/2026. So the case is stated to be at the stage of committal, and pursuant to grant of the interim, the petitioner is stated to have appeared before the learned committal court, learned court below. So the scan record has been received, but it pertains to a POXO case from Shivsagar. Therefore, the registry is requested to kindly verify the matter, and if the case, the scan record of PRC number 493 of 22 arising out of Khetri PS 17 of 20 has been received from the court of learned SDGM S2 Kamrup M. The same may be placed before this court. In the interim, bail shall stand extended till the next date of listing. We can take it up day after tomorrow.
Yes.
Or on Friday.
Yes.
Huh?
Friday.
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 30.
Very good. Lordship,
Trees.
can it be on 2nd of
Yes,
February?
it can. 2/2. You have two matters, no? You-
Two connected matters are there, 48 and 49.
I am for 49.
Yeah. Okay,
We
no
take-
problem. Both on second, same day. of course.
Item number 50.
Lord, I am on interim. CD was called for. The FIR is registered under section 74, 79 of the BNs.
Diary has come?
Yes, my lord. Diary received, my lord. He appeared, my lord. Now, my lord, the victim is also a my lord. That is the my lord wife of a my lord police personnel who is an Assam police, and the my lord accused petitioner is from CRPN. His statement is recorded. Otherwise, one eyewitness is also there because allegation is that that point of time, my lord, the victim was sitting in the my lord that is a restroom of the police station. This is the part. Otherwise, the statement recorded, and these are the my lord independent witnesses also. Accused also, my lord, his statements is also recorded. His statement, he said that he knew the lady earlier. Her statement is that he is a stranger. But victim statement is that the accused is a stranger.
Oh, stranger.
Yeah. But accused said that
He knew the lady.
Up to 4. The petitioner was granted interim bail on 9/1/2026. The case diary has been received. Pursuant to grant of interim, the accused appeared before the IO and his statement has been recorded. In which he has stated that he did not have any bad intention regarding the alleged incident. And that he also knew the alleged victim woman. However, the victim in her statement is denied, stated that he is a stranger and he unnecessarily touched her face. Full stop. Statements of several witnesses have been examined. Statements of the husband of the petitioner, husband of the alleged victim, and some other witnesses have also been recorded in the investigation. The circumstances, I do not deem it necessary to cancel the interim bail. So accordingly, the interim bail granted earlier, hereby made absolute, subject to the condition that will cooperate with the investigation, shall not in any manner intimidate, harm, or harass the informant/victim and our family members. Violation will make the bail liable to be cancelled. Return back the case.
Much obliged.
59.
Lordship. Lordship. The senior is no.
CD receive, my lord.
No time.
What is the allegation?
My lord, here allegation is that, my lord, he has taken the vehicle on rent, my lord. Thereafter, he has to return the vehicle, my lord. And the investigation is going on, my lord. The vehicle is yet to be recovered.
Right.
That is the thing, my lord.
He was granted interim.
Not my lord. He is the person, my lord, who has taken the vehicle, my lord, on rent, my lord. But till today, he has not returned the vehicle, my lord. And IO has filed some objections regarding that, my lord. Since the vehicle is not yet recovered, my lord.
Samarjit Bora.
His interrogation is required, my lord.
Private bail. It was given by rental agency.
My
So,
Rental.
yes, Lordship, thing is that he was not in agreement with me. The petitioner is not in agreement informing the informant. Lordship, only to get some benefit, Lordship, he has included me. Lordship, kindly go to the FIR, Lordship.
Yes.
I'm
You can read it.
I'm reading.
23/11/25.
Yes, 23/11/2000. That is, first part is their own, that is details of the engine number, series number. The next part on 15 November, I'm reading from that part, Lordship. On 15 November 2025, I entered into an oral agreement. Lordship, that's a very interesting oral agreement with Zoo Road rental at an agency operating in Guwahati, whose owner is Mr. Tanmoy Raj Borahi. Contact details so and so. The agreement was for the rental of my above mentioned car for a period of 2 days, with a scheduled return date of being the evening of 17 November 2025. The booking was communicated to me by Mr. Ricky Nath. That Ricky Nath was communicated to him. With my consent, he has consent, with my consent, on 15 November 2025, Mr. Tanmoy Mahendra Rentals took possession of my car from Mr. Ricky Nath's residence at Mamoni Royson, Port New South Sarnia. On evening of 17 November 2025, the scheduled return date, I asked Ricky Nath about the car. When Ricky Nath contacted Mr. Tanmoy, he requested an extension of the delivery date, which we did not agree to. Upon noticing something wrong, I arrived in Guwahati on the night of 17 November 2025 myself, and Ricky Nath immediately questioned Mr. Tanmoy regarding the car status. Mr. Tanmoy Raj Borai then stated that he had rented out my vehicle to the so-called Kishudas without proper verification and the identification documents submitted by the said persons. He did not even take the driving license. The delivery of my car was done by Tanmoy Borai at Joyanagar, Tayaham office in his statement. As for the time of filing report, the vehicle is nowhere to be found at the owner of the Zoo Road. I strongly suspect that Tanmoy Raj Borahi, the owner of Zoo Road Rentals, have committed a serious offense involving criminal breach of trust, cheating, and possibly organized criminal conspiracy. It is their intention. My contention is, Lordship, kindly go to my para number 4, Lordship. I have elaborately stated my contention, Lordship. Page number 3, para number 4, Lordship. Para 4, from para 4, Lordship. The petitioner being instant FIR filed the informant is a cooked up story. The petitioner, as the petitioner on oath, states that he has never been in touch with the informant from 15/11/2025 or any other date till he met him along with Ricky Nath on 17/11/2024 for signing an agreement of the stolen vehicle on back date, declaring that the petitioner had hired the said vehicle from the informant. He asked me, the informant along with the Ricky Nath came to my office asking to sign in a backdated agreement, Lordship. I am never in touch with the Ricky. Even the phone details also may be recorded, Lordship. Phone details also, I am never in touch.
But it was done through this Ricky Nath or something,
Ricky Nath. It was done through
Ricky Nath,
but he says that he has given, Lordship. The fact that
the vehicle is not found, that's the problem.
Vehicle is not found, Lordship. I think, Lordship, only I may give some information also. Only the thing is that, Lordship, updated case diary was called for. Even I may be given a protection, Lordship, to state my statement. Even if Lordship may reject my bail application also, plus record my statement, Lordship. Only that part will lead the truth. Because here, Lordship, if Lordship goes to the FIR, Lordship, even the prosecution case also is not that strong, Lordship, because there is an oral agreement they have stated, Lordship. There is nothing to state. Even the GPS statement, GPS is there, Lordship. So the
The vehicle was given to someone else.
My lord, it was given to someone else without the consent of the my lord complaint informant.
And that vehicle has.
No,
What
it was
happened to
consent.
the
The consent is being stated in the FIR, Lordship. They have stated that this is
Not yet recovered, ma'am.
The vehicle has to be recovered.
but the GPS system is with the owner, Lordship, not with me, Lordship, at any point of time.
Ricky Nath, let's just see what Ricky Nath says.
Ricky Nath is also an accuser, in my opinion, Lordship, as my understanding, Lordship. So I am the car rental agency. I used to give he only asked, I have never given, Lordship.
No, but getting the vehicle and giving it to another.
So that I have not given, Lordship. He is
denied.
I am denying it, Lordship. He is saying, he also cannot prove it. He is saying that it is oral agreement. If I
But
being a
Ricky Nath contracted with the my lord.
sorry, if being a rental agency, why should I give a car to anybody without being an agreement, Lordship? He asked me to for an agreement, Lordship. Let the truth come, Lordship. Only the truth should come, Lordship. I am not for that innocence. So I am for that, Lordship. Lordship, on last day, I was not there, Lordship. Updated case that he was called for. Lordship, in that case, Lordship, my humble prayer, Lordship, because that my statement may be recorded, and if my statement also may be tallied with the, so truth should come. You see, here, Lordship, he is saying that everything is with his consent. In the FIR also, he is saying the consent. As there is GPRS system, the owner knows everything, Lordship.
GPRS system.
GPS system is there, Lordship. Owner, it is with the owner, Lordship. It is not with the anybody, Lordship. Not with the Ricky Nut, not with
Otherwise,
the.
rental business, this kind of rental business will never work. There has to be some GPS.
Mm.
Has to.
Yes.
From the
Anyway,
statement of the complainant, Lordship.
Let me see the statement of Ricky Nath also.
Right.
Let me see. Initially made a. He should not have given like that.
Lordship.
No, he should not have given without verifying this person.
No, Lordship.
So that-
I have not given. It is Ricky Nut given.
Let him record the statement. No, we'll keep it pending. We'll let him record the statement and then we'll get back the case diary and again see.
Lordship.
So
But his involvement is there, man. This is the.
let him say
Minor.
his version. Otherwise there should not be any delay. However, the case diary has to be returned back
Minor.
without delay. Full stop. The gist of the allegations in the FIR dated so and so is that the accused petitioner is the owner of a rental agency and the informant had rented out his Maruti vehicle, Bronx vehicle, to the said agency owned by the petitioner through one Ricky Nath. Full stop. It appears that the said Ricky Nath, he is referred to him as brother. Own brother.
No,
Not. Full stop. Anyway, the vehicle was supposed to have been returned. When the vehicle was not returned by the stipulated date, they started making enquiries, and thereafter it was indicated that the petitioner herein unauthorizedly gave the vehicle to another person whose ID turned out to be fake, and the vehicle has remained untraced. The learned counsel for the petitioner submits that the petitioner wants to record his statement to bring forth the complete facts.
Yes.
The learned additional PP submits that the investigation has indicated involvement of the present petitioner as well. It is revealed from the statement of the Ricky Nath that the petitioner acknowledged that he gave the vehicle to the third person without properly verifying the credential. Said that. I think. The case diary be returned back and procured again by the next day. In the meantime, to enable the petitioner to record his version of events, it is directed that in the interim event of his arrest, 30,000 with 1 security, the satisfaction of the concerned learned court and subject concerned arresting authority and subject the condition that he shall render full cooperation to the investigation. Secondly, he'll appear
Greatly.
before the IO, making himself available for examination. He shall render full assistance within his capacity to help in recovery of the vehicle.
It's fine.
17-2, my lord. 17-2.
Little earlier, maybe. Little earlier also it
We
can
will have to send back.
send back this. 72.
17-2.
Greatly obliged, Lordship. Greatly.
One more.
Item number 60,
60.
item number 60.
60.
Please, your lordship.
Yeah.
My lord, scan copy of the, my lord, case record as well as, my lord, the TD and SAR status call for, my lord.
Let's come. What is it pertaining to?
My lord, affair is page number 16 is relating to, my lord, dacoity, my lord. SAR sheet already filed, my lord.
Charge sheeted case, right?
My lord,
Not received, so
my lord.
wait for some time then.
My lord.
Not yet received, yes. As per office note dated 22/1/26, the scan copy of the TCR is not yet received. Issue fresh requisition for the scan copy of the scan TCR comprising case diary and charge sheet of Mankasar PS case number 620 of 2025, PRC number 418 of 24. How can it be 25 and 24? Its number would be 25 also. Ah. Yeah. What is the PRC number?
My lord,
It's of 25, right?
yes, your lord, 24,
Huh?
24.
The case number is Mankasar.
PRC case number 418 of 2024.
And Mankasar PS case number?
Mankasar PS case number 620 of 2015.
2015.
My lord.
25, no, 15. Probably. 15. And PRC number 418 of 2024.
25.
16.
60.
List the matter on.
My lord, any date, my lord, before, my lord, 10 to 2000.
Before 10 to.
My lord.
Oh, no problem. Just give it after.
Ali oblige, your lordship.
Take the date.
My-
We can fix it on.
my lord,
7 also we can fix. 7 is holiday,
Yes.
working day now.
yes.
7 is a working day now. 7/2.
My lord. Ali oblige, your lordship.
Time being at 5.
As per my instruction, my lord, in this case, charge sheet submitted on 18/1/26, my lord. Against the present petitioners also, my lord, charge sheet submitted.
That is after the statutory period.
Yes, after the,
Yes.
no, my lord, before.
During the statutory period, my lord.
During the statutory.
Yes, the statutory period would have been on 22nd. My lord, if so, my lord, let this, my lord, be recorded and I will approach the court below, my lord. My lord, date and CS number may be recorded.
This report may kindly be kept as a part of the
Exercising her T.H. Hadarika, learned counsel for the petitioner, and P. Bhatnagar, learned additional people, invoking 483 BNSS. The petitioner is seeking regular 483 BNSS. Petitioner is seeking, the two petitioners are seeking regular bail in connection with Bokisto PS case number 551 of 2020. They were arrested on 25/10/2025. Upon instruction, the prosecution has submitted a communication dated 21/1/2026, revealing that upon completion of investigation, the case has been charge sheeted on 18/1/2026 by CS number 13 of 2026 under section so and so. 510. So In the context of the learned counsel for the petitioner submits that he may be given the liberty to approach the learned trial court for bail. Allowing the said prayer, the instant bail petition is disposed of with the observation that the petitioner shall seek regular bail from the learned court bill.
Yes.
Which shall be disposed of.
Yeah.
Needless to say, in accordance with law.
Yeah.
So keeping in mind the stays of the case.
Yes, deeply obliged, my lord.
Stands allowed, stands disposed of.
Yeah, deeply obliged.
23, 24. 20. 23, 24.
So what 23 is concerned, my lord?
23 such, my lord, case diary received, my lord. Regarding 24 CD not received.
They are separate cases.
Separate, but the person accused is same person. But your lordship might have remembered,
Yes.
that last time we have, I've argued on the basis of constructive custody.
Mhm.
What is the meaning of constructive custody?
Yes.
That your lordship has
I did not
reserved
go,
the judgment and ultimately passed an order.
did not go so much into it anyway, so
Yes, yes.
this matter, otherwise, he's on interim bail now,
There is an interim bail
On medical ground.
on medical ground.
on medical ground.
And by that, if you go by the policy, principle of constructive custody, already that period is over.
A difference of opinion, between
Difference of
ideas,
opinion.
actually. Some say that.
There are two
it should be
judgments I have
excluded.
already given,
Yeah,
my lord.
some say it should be excluded, some say it should be included.
Yes, yes.
Logically, it
Martial
should be
law-
excluded, I think.
Yes, yes,
logically.
yes.
But there's no authoritative pronouncement of the Supreme.
Your lordship also observed this thing, that this is a matter of argument, not clear. So your lordship, in one case, same similar case, your lordship granted bail. Made it absolute.
My lord, regarding one judgment, I have also gone through, my lord, recently. Your lordship may kindly fix it day after tomorrow. I will provide that judgment, my lord. And regarding, my lord, the order passed by your lordship, that order also I have not gone through. So
No,
I
this
will
I
have
did
to.
not go into that aspect.
Your lordship has
Decided on the-
just observe it, my lord. In
this-
this order, you have taken a constructive custody. You have observed, but it is not clearly
My,
written.
see, the thing is that some difference of opinion, some high courts have said.
Yes.
Yes, yes. In Bafana case,
Should be excluded.
yes, Bafana case, you already
Uh,
explained about that.
Logically, if you see, logically, perhaps it should be excluded, but
Yes,
that
yes.
is just academic opinion. In
That is academic discussion.
but
Clear that
or there's no authority, any clear pronouncement. There's no pronouncement
Yes.
of the Supreme Court.
Yes, yes.
only
Okay.
High Court, High Court has passed
Some
an
of the
order.
High Court rejected, my lord, that content.
Anyway, so day after tomorrow. It's on interim bail also.
No, if your lordship wants to, my lord, dispose of, my lord, I will leave it to your lordship. But regarding that, yes.
Have a look.
And regarding item number 24, my lord, CD not received.
CD is not received.
They did not receive, but same constructive custody. Custody, that mandatory period is over.
This would be from which police station?
My lord?
No, this next matter.
Next
Police
matter from Bosisto, my lord.
Police, so we can fix it. How about fixing it on Thursday? And
Yes.
issue requisition
Yes.
CD, and this one you submit the judgment. It will be more realistic.
23 CD received, my lord.
Yeah,
Did you receive, your lordship go through the CD and
the case diary has been received. Also. However, the learned prosecution, the learned additional PP for the prosecution seeks to submit a case law. So the case diary be retained, interim granted stands extended till the next date of listing. This is the matter on 29/1.
Yes.
2026. In this, there is no interim, right? There is interim here.
yes, all cases.
In all cases, my lord.
All cases.
The case diary is not yet received. Issue press requisition for the case diary of Bokhisto PS case number 331 of 25. The interim bail stands extended till the next date of listing. Okay, so we'll take it up on Thursday. Hopefully the CD comes
Yes.
together. And in the meantime, you can look up that case law.
25.
Oh, it
In this case, your lordship, petitioner is behind bar for
31 days.
631 days, your lordship.
631 days.
631 days. It's a POXO case, your lordship. And in fact, your lordship, out of the 17 witnesses, 7 were examined, including the victim girl, your lordship. Remaining 10 are to be examined, and my ground basically is, your lordship, length of detention, as also that, your lordship, the grounds of arrest has not been furnished to him at the time of arrest, your lordship. That, and that therefore your lordship was pleased to call for the record, your lordship, to see whether there is sufficient compliance of provision or not, your lordship. Definitely. Grounds of arrest, yes, CRPC 190.
Tomorrow.
Your lordship may kindly
Well-
come to para 11 of my petition, your lordship.
Para 11 of
11, where I have made specific statement, affirmance that grounds of arrest has not been furnished. That is,
That we have to look first then, right?
lordship,
That we have to look first.
lordship.
Length of detention and grounds of arrest.
Lordship, these are,
Grounds of arrest should come before. So
Lord,
that would prevail over other things if it is not
Lord.
there, right? Cases, several witnesses, almost half proves.
lordship,
Half-
7 were examined, your lordship. More particularly, the victim girl has already been examined,
7 witnesses have been examined.
lordship. And in fact, I have annexed all these statements, your lordship. In some of the statements, I have been implicated, no doubt about this. But ultimately,
Hmm.
my fate will determine by the outcome of the trial, your lordship.
Oh, yeah,
Lordship.
arrest memo.
So therefore, your lordship, I am not on merit,
Is it
only on the
here,
ground that,
Could you procure the 47, 50 notices here?
yes, your
On the
lordship,
arrest.
I have, your lordship.
This one. Obviously, this will not do.
Annexed 2, your lordship.
Page 25.
Page 24, 25.
Yes, you can, you are appearing for amica, you are as a max. It's all your some, look at. First, let us see this
Mine.
aspect of, this grounds.
Right.
Because if it is not there, then it becomes a necessity.
Mine.
It becomes a mandate to grant bail. Without going into merits. Could you identify this notices from the record?
Mine.
This record?
I have to verify.
Hmm?
I have to verify, my lord. First
Verify. No, I'm just having a look.
Mine.
You can have a look. I see this.
Yeah.
Is the copies which he has annexed, that 50 notice will not
My
do.
lord, my-
That will not do.
my-
Because before, at that time, it was given like that only.
My lord.
But we have to.
At that time, this
Yeah,
was continued.
that
My
was the
lord.
format.
My lord.
You have to judge it. You have to assess it on the basis of the law prevailing now.
My
It
lord.
will not do. That's okay, but just cross check it. Must be the one. Same notice must have been
Yes, your lordship.
annexed by him. These are all order sheets.
Okay, no?
Relevant.
Okay.
Bahar Ali.
Bahar Ali. Bahar. Sorry, এটা আছে।
It would be there in that note, violation. It's not here. Start doing part of the work. You know, heard. It's what I and counsel for the petitioner. Start
If your lordship,
learn additional people.
if your lordship permits me, your lordship, another matter is going on, your lordship.
Yeah, you want to go there?
Yes,
So let me peruse what
he will
happened.
be here.
Yeah. Invoking 483 BNSS and Mr. S. Nawaz, learned amicus for informant. Invoking 483 BNSS, the two petitioners herein are seeking regular bail in connection with Dudnoy PS case number 35 of 24. Under section 376D, read with section 6 of the POCSO Act. The petitioner number 1 was arrested on 7/5/24, and the petitioner number 2 on 6/5/2020. Presently, both of them are in judicial custody. And it is submitted that their under trial detention so far is in excess of 600 days. Full stop. The gist of the allegations out of which the case arose is about intoxicating the victims and subjecting them to rape by 3 persons. Full stop. After completion of investigation, the charge sheet was submitted on 31/7/2024 under section full stop. Subsequently, charge has been framed against the petitioner. Charge has been framed against 3 accused persons under section 376 POCSO Act, read with section 67 IT Act, read with section 376 AB. 376D, sorry. Cross check for playing there, yeah. Cross check. Anyway, the case is stated to be at the stage of prosecution evidence, and several witnesses have
Seven witnesses already.
seven witnesses have been examined,
17 witnesses.
including the victim. The scanned TCR is fall for has been received. The learned counsel for the petitioners seeking bail primarily contains 2 grounds dash that comma the grounds of arrest as stipulated under section 50/50A CRPC within bracket as it existed then have not been furnished, and secondly on the length of detention.
My lord, here my submission is that, my lord, out of 17 witnesses, my lord, 7 already examined, my lord. Here, both the victims, girl, my lord, implicated the accused person, my lord, how they have involved in this case, my lord, how they have committed the offense, my lord. And here is the, my lord, PW7, my lord. Here is he is also, my lord, corroborated the evidence of, my lord, PW1 and 2, my lord. Here, when he went there, my lord, he found that, my lord, PW3, my lord, Prafulla Kasari, my lord, he found that both the guards were in neck condition, my lord.
I've read that.
My lord. That, my lord, here, my only submission is that, my lord, here, some of the material witnesses are yet to be examined, my lord.
That is there,
It
but
may-
first you have to see this. Could you?
My lord, it may hamper or temper the evidence, my
on
lord. That
merits,
is one part, my lord.
it's a
Regarding the 50, my lord, notice, my lord, that,
considerable length of detention, but on merits, it's a
my lord,
bit of a serious matter.
my lord,
So this is the notice, right?
my lord, that is the fact, my
The earlier notice, earlier format.
My lord.
This was dated, when were they arrested? 7/5/24.
1, my lord.
6/5/2024.
1,
7/5/2024.
1, 6/5/24 and another is 7/5/24.
Problem is that this will not do.
My lord.
This will not do. That's the thing. Anyway, thankfully, at least there is some progress in investigation.
My lord, my
You
lord.
have to impose, you please submit regarding that.
Let's say that my lord, the victims have implicated,
Hmm.
but the fact remains, my lord, he has not been
Hmm.
compliant. So they are entitled to benefit of
Hmm.
non-compliance.
Hmm. That is the thing. Otherwise, in a normal course, generally
My lord, it
speaking,
was,
length of detention is also considerable.
here length of detention is not perhaps
but
not
still-
consideration as already 7 witnesses already examined, my
Still-
lord. My lord.
Still, anyway. 2 persons are here. Now, what about the third accused? He's on bail or something?
No, my lord, that is,
Don't have instruction. The learned additional PP submits that on merits, the both the victim girls in their testimony during the trial have implicated the accused persons, and the
PW.
same also finds corroboration from other parts of the prosecution evidence adduced for. Mr. Nawaz, learned additional learned amicus, appearing for the informant, supporting the contentions of the additional PP, submits that the testimony so far has implicated the petitioners. The petitioner side has annexed copies of the notices under 50 supposedly given to them at the time of arrest. The said notices are also available in the scan record and may be reproduced here in below. Very well. Full stop. I've given my consideration to the aspect of length of detention, which is undoubtedly on the higher side. So, however, most importantly, the aforesaid nature of the notices of ground of arrest given to the accused at the time of the arrest would not satisfy the mandate of law as laid down by the Honorable Supreme Court. It would not satisfy the mandate of Article 22(1) of the Constitution of India and the laws laid down in this regard by the Honorable Supreme Court in the cases of Bihan Kumar and Prabir Prakash. In these decisions, it has been held that if there is such infirmity in the notices, in the infirmity in the notices pertaining to grounds of arrest, the continued detention of the accused would become untenable, and the accused becomes and the accused is required to be granted bail in such a situation. Therefore, despite the serious nature of the alleged offences, but keeping in mind but considering the infirmities in the notices under Section 50 pertaining to grounds of arrest and the law governing the subject that prevails at the moment, the petitioners are required to be granted bail at this stage. In any case, they are in under trial detention since May 2024, and trial has also progressed, including the testimony, including the evidence of the victim girls. 50,000 with one security each, to the satisfaction of the concerned learned court, which will be session judge. Which district? Goalpara.
Goalpara.
Special judge Goalpara. And subject to the following condition, it shall be available for the remaining time. Shall not hamper or tamper with evidence. It shall not in any manner intimidate or harass or harm the informant or victims or any witnesses who have deposed or are yet to depose. Violation of the bail conditions will entail cancellation. The bail petition stands allowed.
Here, my lord, with all respect, my lord, charge sheeted case, my lord, LCL was sought for, my lord.
Mhm.
And my lord, CS has been submitted, my lord, not partial, my lord, absolutely complete, my lord. Here, my lord, if we look into the FIR and my lord, with all respect, my lord, other material, all the accused persons were arrested after lodging of the FIR, and there is a gap of around 16 days, my lord. And if the forwarding report and other materials are looked into, whichever is available to us, my lord, on circumstantial evidence. My lord. Now, question comes, my lord, a driver, with all respect, my lord, his wife was having an affair with somebody, my lord.
Mhm.
So it was a contract killing, my lord. And most of the evidence, if not, my lord, whatever we have found, my lord, with the documents available with her, my lord, forwarding report and everything, my lord, absolutely on circumstantial evidence. Now, question comes, my lord, gravity of offense and everything. In the Indian criminal justice delivery system, as a student of law, my lord, if attendance can be procured, my lord, and if it is absolute charge sheet, my lord, have I made my position clear, my lord? If further investigation is on, even then, my lord, bail is the rule and non-grant of bail is the exception, my lord, despite gravity of offense, my lord. Who has done what? Let him face the trial, and when it is circumstantial evidence, my lord, it is very difficult on the part of prosecution to prove the case. This is our case, my lord, and with all respect, my lord, one Gujarat MP's case comes to my mind, my lord. What the apex court has said there, my lord. With all respect, in that case, partial charge sheet was submitted, my lord, and there, my lord, one paragraph is very important, my lord. Can I just paste it, my lord? Because here, after grant of, sorry, my lord, after submission of charge sheet, possibly bail is the rule and non-grant is the exception. Non-grant is as regards flight risk and everything, my lord, if it does not appear. Because now, when, my lord, an absolute charge sheet has been submitted, my lord,
Mhm.
keeping them like gunny bags in jail would not facilitate, my lord, further police investigation, because investigation has come to a standstill, my lord, an absolute standstill, my lord. Here in this case, my lord, in that Gujarat MP's case, my lord, 2 pleas were taken, my lord. That, my lord, copies have been served and he was an MP. That was negated by the apex court, my lord. Apex court just said, my lord, that, my lord, partial charge sheet has been submitted. In that event, my lord, there is no chance of tampering with evidence, my lord. May I read para 64, my lord? This comes handy possibly, my lord.
64, no?
64, my lord. There, Learned Counsel Mukul Rohtagi was there. Lordship may have found, my lord. I'm sorry, my lord, to a parting, my lord. Parting paragraph, my lord. 68 is the parting paragraph. Last page, my last but one page, my lord.
Yeah, found it. We have
With-
already noticed this. Stuff
may,
like that?
may I read, my lord?
Yes.
We have already noticed the submission of the Learned Counsel for the parties on this application seeking bail in the main judgment. The appellant petitioner was arrested on 5/11/13 when he appeared before CBI in response to summons. Since then, the appellant petitioner has been in custody. We are here in custody 3 months, 22 days, my lord, drawing a parallel, my lord. The supplementary charge sheet has been filed there, my lord, incomplete charge sheet. Have I made my position clear, my lord? The supplementary charge sheet has been filed by CBI in the Court of Additional CJM Ahmedabad on January 24. After the charge sheet being filed, obviously the appellant petitioner is no longer required for further investigation. This is the ratio, my lord. Next, my lord, Mr. Rohtagi has rightly pointed out there is no likelihood of the appellant petitioner tampering with evidence as the copies of all the sensitive statements have not been supplied to the appellant petitioner. Same is the case here, my lord. Then, my lord, if the copies are supplied, then one, my lord, parameter comes, my lord, that he will be able to know the witnesses who are of importance, my lord. Have I made my position clear, my lord?
Yes.
Exactly the same, my lord. We stand on a better footing Here it is, no further investigation is going on, my lord, absolute charge sheet, my lord. Thereafter, he made another prayer, my lord, page 65. We are not much impressed by the submission of Mr. Rohtagi. The appellant petitioner ought to be released on bail simply because he happens to be a sitting MP. Nor are we much impressed by the fact that further incarceration of the appellant petitioner would prevent him from performing his duties either in parliament or in his constituency. This was negated, my lord. So far as the court is concerned, the appellate petitioner is suspect accused in the offense of murder. Exactly the same here, my lord. No special treatment can be given to appellant petitioner simply on the ground that he is sitting member of parliament. It goes, my lord. However, keeping in view that the CBI has submitted the supplementary charge sheet, my lord, we stand on a better footing, my lord. It is absolute charge sheet, my lord. And that the trial is likely to take a long time. We deem it appropriate to enlarge the appellant petitioner on bail subject to following conditions, my lord. So here, my lord, bail is the rule, and with, my lord, one single default on a subsequent date, my lord, to lead to cancellation of bail, my lord. Our lordship rejected it earlier, my lord.
At the
You-
time, it was an investigation. right?
Exactly. That is why it has come before your lordship.
Anyways. Now,
My lord.
diary has come for you.
My lord, scan copy received, my lord. We
Okay,
have received the scan copy, my lord. Here, my lord,
Can we see the charge sheet? Is that?
my lord, I have played,
Yes,
my lord,
you're
the search
right.
in my lord. Cognizance taken, my lord, only cognizance taken under section 61 to 1031, 238A, 35 of BNS, my lord.
Hmm.
And here, my lord,
61-2.
my lord, 61 subsection to 1031, then 238A, my lord, and 35 BNS. My lord, here, lordship may kindly pay the rejection order, my lord, here. Page 27, my lord, of the petition, my lord.
Hmm.
67.
Page 27, my lord.
I've seen.
So and so, my lord. Crime scene officer has been pointed out, and it is submitted that the crime scene creation has dealt with the materials pertaining to the severe analysis, my lord. And during the investigation, I has collected, my lord, sufficient materials regarding them, my lord. And here, charge is yet to be framed, my lord.
Hmm.
Only cognizance taken, my lord, and it was committed to the session court, my lord. And as the charge not yet framed, my lord, there may be some chance of, my lord, for hampering and tempering the evidence, my lord, witnesses, my lord. And already my senior already said it is a contract killing, my lord. From the statement, it reveals that, my lord, rupees 5 lakhs were contracted for killing the, my lord, and disease, my lord, and 1 lakh already paid. And all of them are involved in this, my lord. How it is from the charge sheet, my lord, how they have planned, my lord, for killing of the, my lord, disease, my lord. My submission is that at this stage, my lord, lordship may not
Not be
allow them, my lord. My strong
objection.
objection is there. At
May-
least some witnesses may be examined.
May I add a line, my lord?
Yes.
My lord, here, my lord, only two
Prosecution.
things, my lord.
Yes.
With all respect, my lord. That concept, my lord, that, my lord, charge has to be framed, my lord. That is in embargo containing acts, my lord. Have I made my position clear, my lord?
In
Embargo containing acts, my lord. Embargo containing is, my lord, NDPS, Unlawful Activities Prevention Act, my lord. My lord, whether charge framed or charge is not framed, my lord. If charge not framed and bail is granted, is there any possibility of tampering with evidence? Different parameter, my lord. And if charge framed,
the
same
only,
parameter, my lord.
you know,
That cannot be a leg of argument, my lord.
also saying
My-
subject
Same,
to-
my lord.
subject to correction is that at this stage he is no longer needed for investigation.
Exactly.
Subsequent investigation can always continue. At this stage, see, most people don't abscond also.
Yes.
This is also a reality. But most people don't abscond also, especially in when all our data are all, you know, it's all electronic databases there, like Aadhaar and all that. But at this stage, the main concern is tampering of evidence,
Exactly.
the influencing of witness.
My
That is the only concern. Abscond, frankly speaking, in most cases, I don't have, as a court, I don't have concern because I've seen people appear. Some cases they do. They can again be brought, you know, by issuing warrant. But thing is that in a few cases, you have to, they permanently disappear. You cannot find them. But it is increasingly difficult now because of that all our data are tracked. All not tracked actually. records are there.
My lord.
Records of all citizens, all people are there. Anyway, so in a way that's good also. So investigation is over. That part is over. The only concern is this. The only concern is
And also
yes,
critically
whether yeah, that is the only concern.
My lord,
So that
critically
will need
often.
some. We have to.
Crime scene, all police witnesses, my lord, cannot be tampered with. My no
Some
doubt.
cases, in some cases, in my humble opinion, once investigation is over, straight away you can perhaps, think of giving bail. But in certain cases, you
My
will
lord, my lord.
think
As your
a
lordship
little more.
pleases. Yes,
Little more.
yes.
Regarding the statement, my lord, I have flag mark, my lord.
Hmm?
I have flag mark, my lord, regarding the statement.
No ocular witnesses there, my lord. Circumstantial evidence, 16 days thereafter, my lord. Interrogation would not facilitate anything.
Start. You can sit down and do.
My lord.
If you have some work, you can stay. You can proceed. We see. Third, Mr. V.K. Mahajan, assisted by N. Mahajan, learned counsel for the petitioner, and it has learned additional PP for the state / prosecution. Invoking 483 VNS, the 7 accused petitioners are seeking regular bail in connection with Jogi Gopa PS case number 108 of 2025. They were arrested on 6/10/2025 and presently in judicial custody. Full stop. The case arose out of an FIR dated 25/9/2025, lodged by one Amol Boni, with the allegation that on the previous day in the evening, his brother, his brother Raju Bonik, who was a driver, had taken passengers from Himoluguri in his vehicle bearing registration number AS 14 H6766. It is further alleged that on the next morning came to be known that he was killed by some miscreants, and his dead body was left at Boali Mari, Part 1. So and so. The present petitioners were arrested during investigation. This is a subsequent bail petition, as an earlier bail petition was rejected on 18/12/2025 in BA 3549 of 2025 after perusal of case diary. Full stop. Mr. Mahajan, learned counsel for the petitioners, submit that in the meantime, investigation stand completed and a charge sheet has been submitted, and therefore he renews his prayer for bail for the petitioners in this subsequent petition. Stop. Referring to a judgment of a Supreme Court in Dinu Bhai, so and so, 2014, 4 SCC 626. The learned counsel submits that as the investigation stand complete, resulting in a charge sheet, not much purpose would be served by continuing the detention of the petitioners. And it is also submitted in this regard that they shall be fully available for the trial, provided by any conditions imposed. The learned counsel has drawn my attention to para 64 of the same judgment, which may be reproduced here in below. After completion of investigation, the case resulted in a charge sheet on 22/12/2025 by CS number 137 of 25 against all the 7 accused persons, petitioners herein under section 13103 page 29 1032 slash 238A small a slash 612 BNS. Full stop. And case is now at the stage of cognizance. Cognizance has not been taken, right?
Cognizance taken, but.
Yes, cognizance.
Committed, my lord.
That's all.
No,
The
cognizance
case is at
taken.
the stage of the case has passed the stage of cognizance and committed. Full stop. And poised for beginning of trial. Stop. The learned additional PP submits that as for the investigation is indicated the alleged homicide by way of a contract killing. Stop. It is submitted by the prosecution that despite the completion of investigation, there are concerns regarding the trial and evidence, and therefore the prosecution is opposed to the grant of bail at this stage. I've given my consideration to the submissions of both the sides and peruse the materials. Let me keep it. I'll go through it a little bit.
My lord.
Today only I
My lord.
study the materials in detail.
Problem.
Right. Easy dots. Easy. One hearing was there fixed at 2 o'clock. You were there. Would you like to do it? What is this order matter? 61. Take it up later also. Once we start hearing, others matter will not be reached. Missions.
Section.
One is adjourned.
Earlier occasion, I have submitted that one younger sister of the appellant. Wedding ceremony going to be two.
Oh, so that was why
That
we
much.
fixed. I remember now.
My bad.
You both the AMEC. You
Yes, I filed also additional affidavit in IM in item number 52 51.
it's fixed at 2. That's why.
My lord.
The reason behind fixing was only
Yes.
that the IA is pending and the wedding is on 2nd
Yes.
of April.
I can take up the appeal if you.
Yes, Lordship.
You can take up the appeal.
My lord.
That will be better, otherwise it will be a double exercise.
We have all done with the bails. One order matter is there and a few admission matters are there. So we can take it up. Take it up. Since we have fixed at 2, we can take it up. Okay.
Wherein my lord, three accused
There are
person.
3 matters, no?
Three
52,
matters, my lord.
53
Three
and
accused.
54.
Under the same FIR, my lord. Kindly see page 58, my lord, conviction. Page 58.
219, 222, and 223.
my lord. Nipen Rabha, Sone Rabha, Soneshwar Rabha, Nipen Rabha, Jivan Das are sentenced to undergo rigorous imprisonment for 10 years for committing the offense punishable under Section 6 of the POCSO Act, and also paid a fine of rupees 5,000 each only in default to undergo rigorous imprisonment for another 2 months. The period already undergone by the convict during the investigation and trial of the case shall be set off.
Any paper book is there? No, no.
No, no paper.
Anyway, try to manage with this.
It is not
So
required.
judgment is common and
Common in 3 accused,
and 3 accused by convict.
my lord.
So there are 3 appeals.
3 accused. Nine,
Conviction only under 6.
only
No,
under
no IPC section.
no IPC.
Okay. So and trial for 10 years. I know. Okay.
My lord.
Let us start with the FIR.
FIR, my lord. Kindly see, my lord, page vernacular, my lord. Kindly page 65, my lord.
Of your petition.
My lord. Copy of the petition. May I read, my lord?
Yes.
Mohakoy,
Just a minute. No?
my lord.
ভাল tag it up. Just giving you 2 minutes. Otherwise. Okay,
মহাশয় সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱাকালি 30/1/2013 ইং সন্ধিয়া 10 বজাত প্ৰায় 10 বজাত মোৰ ছোৱালী শ্ৰী কৰিশ্মা ৰাভা বয়স 14 বছৰ পিতা ভদ্ৰেশ্বৰ ৰাভা গাঁও হেৰবেৰী থানা 6 গাঁও ঘৰত কোনো নথকাৰ সুযোগ লৈ ঘৰৰ দুৱাৰ ভাঙি শুই থকা অৱস্থাৰ পৰা বলপূৰ্বক চুচৰাই পথাৰলৈ টানি নি উক্ত পদকীয়া তিনিওজনে উপজয় ঘৰ্ষণ কৰি হত্যা কৰাৰ চেষ্টা কৰে। উল্লেখযোগ্য যে উক্ত সময়ত মোৰ সৰু পুত্ৰ ৰাজকুমাৰ ৰাভাই বয়স 12 বছৰ বাধা প্ৰদান কৰোঁতে তেওঁকো বেয়াকৈ মাৰপিট কৰে। মই ঘৰ আহি পোৱাৰ পিছত ৰাজকুমাৰৰ পৰা সকলো কথা জানিব বিচৰাৰ পিছত পথাৰত অচেতন অৱস্থাত মোৰ ছোৱালীক উদ্ধাৰ কৰোঁ। ঘৰখনৰ পিছত মোৰ ছোৱালী কাণৰ সোণাযোৰ পদকীয়া কেইজনে লৈ যায়। সেয়ে দয়ালু মহোদয় শাস্তি দিবৰ বাবে পদক্ষেপ ল'বলৈ অনুৰোধ জনালোঁ। It is the FIR. And my lord, thereafter, my lord, the victim was, my lord, examined, my lord. Kindly see, my lord, page 66, my lord, PW1. Informant is my father. I know the accused person, Sone Rabha, Nipen Rabha, and Jivan Das. I was 14 years old at the time of incident. The incident took place on 31/2013 at about 10 p.m. At that relevant time, I was sleeping in my house with my younger brother, Rajkumar Rabha. On that day, my parents had gone to attend a meeting in the village. The accused called me from outside of our house and asked me to be present in the village meeting which was going on. I opened the door a little and refused to go with them as it was too late. Then the accused person pushed the door and entered inside our house. accused Nipen Raba closed my mouth with his hand and three of them injured me forcibly and took me to the nearby paddy field. The accused tore my wearing clothes and made me completely naked. I shouted, but accused person Sone Raba pressed my mouth and stopped me from shouting. Then Sone Raba forcibly sexually intercourse with me. Thereafter, Jibon and Nipen had committed forcibly sexually with me against my will. The accused person then threatened me to kill if I shout and if I disclose the matter to anyone.
Now subsequently in 2019, the sentence has been increased. No? Now it's minimum 20 years.
In the unamended one, that
10 years. Up to it was 10 years, up to life, something of that. You are representing all the three appellants.
My lord. I'll understand name also, my lord, include G.
Yes.
Sharma.
Yeah. Only submissions can prevent like it. Only submission. 219, 34, 20, 22, 20. Here, but G's. The learned counsel for the appellate, convict appellate, has taken the court through the evidence of the witnesses, prosecution witnesses adduced during the trial. It is submitted that though it is mentioned in the FIR that the informant, who is the father of the victim, had found the victim unconscious in the field, but the testimony of the victim as well as the testimony of the said informant, it is stated that the victim had come back home after the incident. It is submitted that this is an important contradiction between the FIR and the testimony of PW1. Full stop. It is also submitted that the medical report indicates that there were no injury was found on the private parts of the victim, and that the DNA particulars also do not match as per the testimony of the forensic witness. The learned counsel for the appellant has taken the court through the testimony of the medical witness PW and submitted that though the doctor has indicated the margin of age of the victim, but he has also based the same upon a radiological examination conducted by one Dr. MC Das, but that the said MC Das or the radiological report has not been exhibited during the trial. Dr. PW6. Regarding the age of the prosecutrix, it is submitted by the learned counsel, defense counsel, that no birth certificate has been seized and the projected age of the victim is not based on any documentary evidence. Relying on decision of this court in the case of Nakul Kolita versus State of Assam, 2025 1 GLT 879, it is submitted that if such evidence regarding the age of the prosecutrix, merely the statements of the witnesses, the same should not be relied upon. They submitted that the FIR of the case has also not been exhibited. It is submitted by the learned counsel for the appellant that the main witnesses are the victim and her parents, and they are interested witnesses. Summing up his submissions, the learned counsel for the petitioner submits that there is infirmities in the impugned judgment and order dated 5/6/2024 passed by the learned trial court, and he prays for interference with the same and acquittal of the convict appellants. Ms. Pooja Agrawal, learned amicus, appears on behalf of the informant and has taken the court to the testimony of the victim, her brother and her parents. Full stop. With regard to and submitted that testimony of the victim is consistent and reliable. Full stop. Referring to the testimony of PW6, the doctor, it is submitted that upon examination of the victim, the doctor also found tenderness in the private parts, thereby leading corroboration to the allegation of sexual assault. It is submitted that such tenderness cannot be due to a fault. Referring to the relevant portions of the judgment, it is submitted by the learned amicus that with regard to the age of the victim, the testimony, the medical evidence clearly states, clearly indicates her to be below 18 years, including the margin of 2 years incorporated therein. Moreover, the statements of the witnesses are consistent regarding her age of minority, regarding her age. Taking the court through the testimony of the 3 witnesses who have adduced evidence on behalf of the defense, from the learned amicus submits that all the 3 defense witnesses have expressed their ignorance as to whether the accused persons had come to the house of the victim and committed the offense as alleged. It is submitted that the FIR is not meant to be an encyclopedia, and that the evidence adduced during the trial is more important. It is submitted. Full stop. Summing up our submissions, the learned amicus representing informant/victim submits that the learned trial court has rightly convicted and sentenced the accused persons, and that the same may be upheld and confirmed. Mr. Bhattakur, learned additional people, supports the arguments of the learned amicus, and he submits that the prosecution has been successful in proving the foundational facts, whereafter the burden of proof shifted to the accused person during the trial, and that the accused persons were unable to successfully rebut the said presumption against them. Supporting the submission of the learned amicus in this regard, the learned additional PP submits that by the standard of proof applicable, the prosecution has been able to prove and drive home the foundational facts triggering the burden of triggering the shifting of the burden upon the accused during the trial. Okay. With regard to the contention regarding some infirmities in the investigation, is submitted by the prosecution. as well as the learned amic, that the previous statements of the prosecutrix and her related witnesses were not put to the were not put to them during cross-examination, and therefore the non-examination of the first investigating officer has not caused any prejudice to the defense. Summing up the submissions, the learned prosecution contains that there is no merit in the appeal, and that the same may be dismissed by upholding the judgment and order. This much.
Obliged.
I'll make it ready shortly. In a week. Yes, go take it back. Okay, yeah. Okay. There's one one order matter. Should we just seat anybody for that matter is there? There's one order matter, na? WP criminal. What is it about?
Your Lordship, according to the mediation report dated 22/1/2026, we need 15 days more time for negotiation.
Acha.
SF 61.
Some higher purchase matter, something like that. Is it a higher purchase dispute or something of that sort?
Yes, Your Lord.
Why WP criminal? Oh, I've written something. Petitioner. Your name is Yashmin?
Myself, N.A. Lashkar.
Huh?
N.A. Lashkar for
Your-
petitioner.
Your good name?
N.A. Lashkar.
Anil. We have struck off respond number 2, right?
Yes, Your Lordship.
Okay, if it's settled in remediation, good. That's what. Take. Okay. Leave option. Here is the previous order dated 26/11/2025. So, third, Anna Laskar, learned counsel, Miss Anna Laskar, learned counsel for the petition. None appears at the moment for the other side. By the said order dated 26/11/2025, on the prayer of the petitioner counsel, which was also agreed to by the learned counsel for respond number 3 and 4. Matter was referred to the mediation center of this court with a direction to the parties to appear on 6/1/26. Stop. The learned counsel for the petition submits that the parties need please
15 days.
at least 15 more days to take that process forward and arrive at an outcome, arrive at a possible outcome. The prayer is allowed. List the matter on so and so date for settlement, if any, and orders necessary. Is the matter again on so and so date in the orders column. So when should I fix it? You can suggest. 2 weeks you take, and then thereafter at least a week.
Yeah.
Should I fix it after 4 weeks or 3 weeks?
3 weeks, Your Lordship.
3 weeks. Okay, so you can suggest a date, or I can also fix it after 3 weeks. Some,
Your lordship, March 6th of March,
no, 3 weeks would be in February only.
then
Three-
19th of February.
Yes, it can be on 19/2. If you want more time, I can keep, but 3 weeks is okay, no?
Yes, sir.
19/2. Then after that, if something is necessary, then can be walked up. Okay, that's why I took it up. Some short matter.
Okay.
19/2. Okay, I mean, how? Okay.
What's
done.
up?
We can just explore this admission matters, what they are about.
Item 70.
Yes.
That is senior counsel, Mr. King Chaudhary was appearing in this matter. He was there, your lordship. The paucity of time, your lordship. Let him be fixed day after tomorrow.
So he was for this matter.
Yes.
Mr. Ganguly.
Lordship, I appear for the informant. Charge sheet matter otherwise.
Here's the last order dated 16/12/2025. Mr. Chetri.
Yes, your
The
lordship.
Chetri Learned Council seeks an accommodation. Yes. With the paucity of time, as in this matter, Learned Senior Counsel Ken Chaudhary would be appeared. Mr. Ganguly appears on behalf of the respondent. Respondent, uh, respondent number two, right? Informant plus bank official. So this will, we can dispose it off at the stage of admission, or we got hearing, then it will take its own time.
Yes, sir. So there, my now when it is what is
Yeah, but if they are disputed facts, though, then again,
only these
it should not be
but
a
there are
matter of trial. It should be possible to arrive at a finding without the need for evidence. right?
Yeah, large number of disputed.
There are similarly situated matters also here.
Place in okay, so matter could not be taken up today due to city of time. The prayer for adjournment made by the counsel for the petitioner side is also allowed. This is the matter on when should I fix it? And it has come earlier. Now I remember it had come earlier.
Lordship has gone to the.
Now I remember.
29th, your lordship.
They have for 29. You have to go to next week.
Day after tomorrow.
Or later, any hearing day, 3rd or 5th, perhaps.
Then 3rd. If possible.
5th.
5th.
But he's always been subject.
All right. Actually.
Yes, please, your lordship. As per order dated 31/10/25, your lordship, the final report of Gwalpara PS case and the CD of Hatigam PS case was called for, your lordship. Your lordship, actually, this is the second FIR, lordship. Already the first FIR has been concluded in an FIR, your lordship.
Oh, please find on the same cause of action. Yes,
Yeah.
file under the FIR.
Yes, your lordship. And this is filed for the quashing of the FIR.
We'll
Your lordship,
see
matter has been
and-
stayed, your lordship.
In this matter, my lord, already, my lord, that is the investigation of the Hatigao police station case number is already being, my lord, stayed by this honorable.
Yes.
Now, my lord, that is, my lord, as because two numbers of cases were there, my lord. That is, my lord, was pleased to call for the, my lord, the final report of the, my lord, Gwalpara case, my lord. So that is, my lord, we are not receiving, my lord. As because, my lord, as because FR is filed, my lord, so it is not available with the, my lord, record also.
This is a stay of order.
Yes, my lord. So shall we pray for a, my lord, next date, my lord, because, my lord, that FR report is not available with us. And, my lord, the CD of the Hatigaon PS is not also, my lord, available today.
Begum
Yes.
and K. Boyso. Filed order dated 12/3/2024. Order investigation of Hatigaon PS 57 of 23. This is also suffered actually. Also, the 57 of 23 was stayed till further orders. The said interim orders continue. Further, the FR of Gwalpara PS. What is the what was that FR of Gwalpara PS case number?
FR,
That we'll need, no? Right?
Yes, my lord. that FR
FR number is 79/23, your lordship.
Sure, no?
Yes, your lordship.
79 of 2020.
23. Dated 31/7/2023.
31. Was called for. Neither of these documents, neither of these materials have been received. So what we'll do, we'll
My lord, one from, my lord, that is from the, my lord, CJM court, my lord. FR may be called for. And, my
FR
lord,
is
the
a CD.
the CD is, my lord, for, my lord,
Yes.
that case, my lord.
This,
On that case,
FR is
FR and the CD of that case may be called for.
Yes.
In the meantime, my lord, that is the prosecution will produce, my lord, that is the
Yes.
CD of the Hatigaon case.
call for the up-to-date case diary. Oh, it's no, it will not be up-to-date. State.
Yes, ma'am.
Call for the case diary of Hatigaon PS case 57 of 2023. Further, also call for the case diary of Gwalpara PS case number so and so, along with the FR submitted in that case being FR number. You have the FR number, no, ma'am?
yes, your lord. 79/23.
From the,
Dated so and so.
from the court of, my lord, that is
From the court of the learned CJM Gwalpara.
CJM court.
The interim order shall continue till the next date of listing. Only then we can effectively take up this.
Yes, my lord. Date may be fixed, man.
You can take a date in, next to next week.
Yes.
Interim may continue, your lordship.
Interim order shall continue till the next date of listing. List the matter on 27. (13/2).
Man.
Yes.
That's a
And your
motion.
lordship, my name S. Nazneen, your lord.
S. Nazneen. Yeah, S. Nazneen. We'll write. 13/2 is okay.
Yes, sir.
Deeply obliged.
Deeply obliged.
98.
I is pending or disposed of?
Yeah, please, Lordship.
Pending.
It's pending.
Lordship, senior is engaged in court number 6, a different matter. So, if possible, I'm not sure if it can be taken up today or any other date may be given.
Yeah. It's okay. Don't worry. So we'll promote it you. I'm just seeing what is the matter.
Lordship, it's a case of area maintenance allowance. When the lower court passed the order, it was 8,79,000 was the pending amount. Then in between they paid 4,35,000, but since July nothing has been paid. July 2025. Last installment has been paid one, that too in 3 times.
This I is for stay.
Because no, for a year vacation of stay order and modification of order.
Oh. I has been filed by your
Lordship. I'm for the wife.
you for the wife. Yes.
Because they challenged the law court order that was before this court, that was also dismissed. Criminal revision was dismissed.
I think we should dispose of this matter on the next date.
Lordship.
Isn't it?
Let them pay something in the
They should pay
meantime.
also. In the meantime, they should pay also.
Let them.
So our proposition is that
What is that interim stay order? Which you are seeking Interim order dated 26/11.
Any interim order. Not still finding IA, the operating portion, page 36 of the IA,
Yes, I
the
found,
penultimate paragraph.
I found out. They're not in a position. 1/3 was direct, right? 1/3 was direct.
No, Lordship, the operative is the penultimate paragraph, after hearing.
After the, that's he has paid, this much he has paid.
Only, Lordship. Now area is 4,35,000.
1,50,000 he has paid,
Yes, paid.
but thereafter he has not.
No, Lordship, as of now, I have paid 4,35,000.
No, no, balance is 4,44,000.
Anyway,
Is not, and is not a poor check.
the monthly was 15,000.
Monthly 15,000. That has been regularly paying, Lordship.
You can suggest a date where we can perhaps try to dispose it of
Lordship.
by hearing, right? Today, in any case, we don't have time.
Lordship.
We take heard today due to paucity of time. So, you, Mr.
Can it be on 12th?
Only
Mr. K.K. Henry.
Mr. Chok. Yes, yeah.
Can it be on 12th February, Lordship?
Well, with the motion day,
No, it's a hearing day.
hearing day.
Or 17, Lordship.
Let's fix it on 17.
Lordship.
We'll try on 7. Okay.
Lordship.
This is the matter.
Deeply obliged.
Along with the
In the meantime, let them pay something.
in the meantime, the petitioner side,
Lordship, it will be difficult for us to, as because I have filed an affidavit.
After July, nothing has been paid.
Lordship,
the order which has been stayed is the payment of direction to pay 1/2, 1/3.
Only 1,50,000.
We can just say like this, that in the meantime, I don't know whether it will help or not. The petitioner side shall endeavor to pay the remaining amounts, but it may not help.
It will not be on that.
Only for satisfaction. No use. Cut it up. So, next date we'll try.
Lordship, make an observation that endeavor shall be made to.
That is,
And endeavor should.
but should I record that out of the arrears amount so and so has been paid?
Yes,
That
Lordship.
can be recorded. It is submitted by both sides that out of the accumulated arrears amount of rupees
79,000.
8,79,000,
We have already paid 4,35,000.
petitioner has paid an amount of rupees 4,39,000.
35,000.
35
Till
Well,
July, till July
till July
2025.
2020
In compliance to the orders of this honorable court. Lordship.
in compliance with the order of this court. However, the land council for the respondent submits that thereafter the petitioner has not paid any amount. Monthly also he has not paid.
No, monthly
Monthly,
that
that
is
is
paid.
Monthly has paid any amount towards the
Arrears.
remaining areas. Thereafter you can write that. He'll endeavor to make. Any case, we'll dispose of the matter. This is the matter on 17/2
Obliged.
and in the admission column.
20.
This criminal petition has been filed praying for quashing of the FIR. So with this case, I think some time will be required for hearing. Lordship. Take up with the date because due to paucity of time, I don't think that would be
Pushing on that.
yes. Regard to ACB case.
PCB,
ACB.
ACB.
Yes.
We have received the CD.
Yes, sir.
Case diary received.
So you, it's under investigation.
But it's under investigation, man. Interim is there.
No, interim is not there.
Not there. Just, you are seeking quashing of the
FIR.
FIR.
Yes. There is a delay of around 12 years in filing of this FIR. The cause
Mhm.
of action leads to, there are other grounds also, Lord.
Anyway. You're Mr.
H. Agarwal.
Okay, boys. Dated 9/9. Case diary has been received. However, the matter could not be heard today due to paucity of time. Case diary you'll send back.
And an updated CD, my lord.
The
Maybe
case
please.
diary be returned and procured again. And the updated case diary procured again for the next day. This is the matter. You can
On 11th, Lord.
11. How about 19? If it's okay for you.
In this case, my senior will be appearing 19th.
19 or 17.
Lordship 19.
19.
19. No. 19 too. We'll see what can be
Lordship,
done.
if your Lordship can indicate in the order, because on the last 3-4 occasions,
It does
the
not
paucity of time the matter couldn't reach. Lordship may kindly give us a liberty to update this matter on the next date. This may be mentioned or maybe fixed at 2 or something. Because on more than 3-4 occasions.
Mr. Agarwal, Learned Counsel submits that on last 3-4 occasions, matter could not be heard due to paucity of time. And submits that on the next date, if necessary, the matter may be upgraded. So I'll remember. Then, or you, if I add another code, you just
make a
draw
mistake.
attention and
Attention to
if
order.
it's this code, I'll remember.
Yes.
Yeah.
DP of it.
Are you hearing? Oh, yes. Now there'll be no time. No time for other. No, not your mind. Others, you kindly take a date. Okay? You take a date for the other hearings.
It's a hearing
I
matter,
forgot
my
that
lord.
there are other
7 years conviction.
No.
My eye is still pending, my lord.
Your eye is pending. No, there'll be no time to. Let me click forward.
Lordship can fix it for the eye.
No, just a minute. 51, no? This is I. I is there. This we finished. I thought we had 55. Who's for 55? Anybody for 55? 55, you have to take it. You take a date for this.
As agreed by both of us, Lordship, can it be on 20th of February?
20th of February, your lordship.
20th of February.
20th.
The matter pertains to
Lordship, the matter is to NIA.
Conviction.
Conviction matter.
Petitioner was
Okay.
convicted against their
appellate
petitioner.
judgment.
No,
Dismiss.
no, Lordship. Petitioner preferred an appeal. While preferring the appeal, there is a delay of 5 days,
Acha.
according to the petitioner's calculation.
Uh.
But the delay petition was rejected. Against that order, this petition
Oh,
is
acha.
opposition of court.
It's only 5 days. Anyway, so
It's not a delay of 5 days, your lordship. According to the calculations, it's a delay of 12 days.
Acha.
Then so
Disputed fact, Lordship.
disputed fact is there.
So, Lordship, records were also called for.
okay, okay. So this you take on which date you
20th of February, possible.
20th.
20th of February.
20. And interim order is there. So that may be continued.
Interim order shall have to continue.
Your lordship, I would beg to like to mention here that the matter has been taken up several times, but the hearing could not be done.
That's
So
happens with
if-
admission.
On last occasion, Lordship, record one of the record has not received. Two tricycle record. That's why on last occasion,
if it could be upgraded on the next date fix, if possible.
I can suggest you.
Yes, your lordship, that's
You said 20th, right?
20.
Yes, 20.
Another
25.
thing you can do.
Yes.
It's because it's going to be new, na. We are not fixing as of now. We have not fixed many matters.
Yes.
The normal list will come. 21st is a Saturday. Would you like to do it?
Actually, on 25th, I have a other matter fixed in other district, Lordship. That is a
then that's fine.
Earlier
Not that,
schedule, Lordship,
It's busy also on that
Yes.
High Court lawyers on that Saturday. They go for
yes,
outstation.
we used to go.
I'm very
outside.
familiar with that actually. Sorry, I forgot.
It's
Because
okay,
they
Lordship.
we used to encourage also people
Yes, yes.
from High Court come to districts and do some. The local bar also feels good. So anyway, then we fix it on 20th, you said, but 20th is a motion day, that's the thing.
Lordship,
I can fix it, but 20th.
interim order may be con-
Interim order shall continue. You see the situation on 20th.
Yes,
If
yes.
necessary, we'll upgrade it.
Yes.
Yes,
If it involves hearing on that limited question.
obliged.
Deeply obliged.
And this IA, we
51.
have to fix a date.
Can be heard on the next date, Lordship, because due to paucity of time, anyway, for IA, we have to place the facts and everything, so it can be heard.
The full
altogether.
hearing.
Yes,
The criminal appeal itself.
yes, appeal itself, Lordship.
If 10th is possible, 10th or 12th.
It is a,
Motion day, no, it has to be a hearing day.
Yeah, 10th is a hearing day.
Then.
you're appearing as amicus.
No, my lord.
I'm there as legal aid counsel for respondent number 2.
Oh, it is a POXO matter.
Yes,
Lordship.
Lordship.
Both 10th or
10 years conviction. 10 years.
7
7
7
years.
years
Lord.
conviction. We can hear the appeal also, like this matter.
Yes, Lordship.
Then you can take a
Well-
case, perhaps
Well,
10th or no.
it is already at the stage of hearing, right?
yes,
Yeah.
Lordship. Well,
10th. What was that? 10th. Okay. If 5th is possible,
No, not before that, not before 12th. Yes, we can fix it, hear it on 12th.
12th.
Hear it on 12th, and should I fix it at 2 o'clock?
My lord.
Then it will surely reach.
yes.
So we
yes,
don't know
my
what
lord.
are the other matters
Because
that day.
it's,
But,
also
you
it's
know,
urging not. Yes,
Actually, you'll also feel better.
Yes,
It's
Lord.
like that. That suppose we fix it at 2, I can fix that. We can fix it at 2.
My lord.
But suppose some 14 matter comes and it's waiting.
Understood.
after
Understood,
that,
madam, but still.
Or we'll all feel not so good.
Yes, Lord.
That is the problem in hearing there. Otherwise, we can fix. We need a clear this thing. So I'll not say 2. We'll fix it. On
Yes,
that
Lord.
day, we'll take a call.
We'll upgrade.
We may upgrade, my lord.
On that day, we'll
We'll
take a
make
call.
a
Mention
plan.
may be made that upgraded.
No, without mentioning at 2, we'll,
Yeah.
if necessary, we'll upgrade. I'll remember.
Fixed.
And I will try to take here this man.
Sure. Obliged.
Bar right.
Deeply.
12. 12. Okay.